All persons having business before the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and its honorable court. This honorable court is now in session. Please come to order.
All right, good morning, everyone, and welcome to the District of Columbia Court of Appeals for our oral arguments on this virtual platform, which will be live streamed for public access. We have 3 cases this morning, the first of which is United States versus MONTERO Kyle. The party's ready to proceed. All right. Counsel for Appellate.
Good morning, and may it please the court. Dan Lenners for the United States. Your Honor, if I might reserve 3 minutes for rebuttal. This case involves what courts across the country have recognized as a quintessential abandonment scenario. After he fell while running from the police, the defendant, MONTERO Kyle, took the contraband-filled backpack that he had been carrying, tossed it over the nearest fence, and continued running, further distancing himself from the backpack he had just discarded. The courts routinely find that this constitutes abandonment, and the defendant identifies no case finding a lack of abandonment under comparable circumstances. And in fact, in Boswell, this court declared that when objects are thrown away or discarded in anticipation of a police arrest or interrogation, those actions viewed objectively evidence an intent to abandon. Similarly, in Mills, this court found that a defendant's intention to relinquish an expectation of privacy will be found if the circumstances reveal a purposeful divestment of possession of the item searched. And that's precisely what occurred here. The defendant purposefully divested himself of this contraband-filled backpack by tossing it away from himself into a yard where he could no longer protect it, into which he would have to trespass or get the homeowner's permission in order to recover it, and then continued running away from it.
Aren't many of those things true in the Shreves case? Wasn't Mr. Shreves fleeing from the police, although not in hot pursuit? So there's that difference. And didn't he leave his property on, private property where he would have had to trespass in order to retrieve it?
Those things are true in Shreves, Your Honor. Shreves is a sort of difficult case to understand because the reasoning is so bare bones. The facts appear that Shreves was on a crime spree, shot an officer, and drove off. And all we know is that the next day someone called and reported that his car had been left parked behind a farmer's market and had been left there for 7 hours. So the officers weren't in hot pursuit, which is a significant difference. Kyle not only knew
why in your view is it analytically significant? So you think Shreves would have come out differently if I don't know what the exact temperature of the pursuit would have to be. Would it depend on whether the police were right behind Mr. Shreves and he'd pulled on and onto property and thought he was hiding his car and then ran off and they saw him? Would it be they were in the area and they'd lost him for a while and he'd left his car? How hot does the pursuit have to be, and B, why does any of that matter?
So I don't know how hot the pursuit has to be. There are certainly innumerable cases where a defendant, while driving away from the police, stops his car, runs off from it, leaving, say, the keys in the ignition, and courts find that the car has been abandoned under those circumstances. And it matters because, in part, it shows what's going on in the defendant's head. When the defendant knows the police are hot on his tail, and in this case can, in fact...
Mr. Lawrence, can I interject on that point? When you say part of it hinges on what's going on in the defendant's head. The difference in the briefs between the appellant and the appellee on this issue intrigued me. the government seems to be arguing that it shouldn't matter as much what's going on in the defendant's head, but more on the objectively reasonable and observable facts from the perspective of law enforcement or other bystanders. And appellees, if I understand their argument correctly, say it solely hinges or primarily hinges on what is going on from the subjective perspective of the defendant. The Eighth Circuit and I think Ninth Circuit or Seventh and Eighth Circuit seem to agree with your position in your briefs that it's more of an objectively reasonable standard. How much does it matter? In other words, what's going on in the appellant's head
I think that
or defendant's? I'm confused because you all are on different sides, which you typically aren't. So,
of course, Your Honor. I don't think it's just the Eighth and 10th Circuits. I think it's also this court that have found that abandonment has both a subjective and an objective component. The court has said it's primarily a question of intent, but that the question is whether the defendant can retain a reasonable expectation of privacy. And for example, in Boswell, the court discussed at length the defendant's objective. I'm sorry, it's just an interruption. In Boswell, the court discussed at length whether the defendant had an objectively reasonable expectation of privacy in the blanket colored television. And in Biles, the court evaluated both the defendant's subjective expectation of privacy in the box that was covered by a backpack, as well as whether society would recognize that as objectively reasonable. And so this court, consistent with the 8th and 10th Circuit cases I cited in my brief, has reviewed both the subjective intent and the objectively reasonable expectation of privacy. And
so what's wrong with the trial judge did here?
Well, primarily what's wrong is the trial court found that the defendant did not intend to abandon his backpack under circumstances in which every other court across the country has found an intent to abandon, under circumstances that this court in Boswell declared objectively evidence an intent to abandon, and that by any common sense finding show that this defendant was trying to distance himself from his belongings.
Temporarily, perhaps, but the trial court, I think, at least arguably inferentially, the trial court's perspective was this, Mr. Kyle wasn't trying to permanently separate himself from these belongings, as sometimes is the case in abandonment settings, perhaps, but rather because of the circumstances and including what was inside the bag, the trial court seemed to implicitly, arguably infer that Mr. Kyle was hoping eventually to go back around and get those things. And so he's temporarily separating himself from them, but he doesn't, he's not permanently severing his hopes or expectations of continued possessory interests or privacy interests in it. Do you think that's an unreasonable, leave aside for a minute objective reasonableness, but just in terms of what Mr. Kyle's intent was, do you think a fact finder could reasonably look at this record and without committing clear error say, well, I think he was temporarily trying to get it off himself, but he planned to go back around and try to get it? Would that be an unreasonable factual inference on this record?
Yes, Your Honor. Kyle was running away from the police. The police were in between him and the backpack. So the idea that he was doubling back to get his backpack from behind this fence where he threw it would be an unreasonable conclusion. It also doesn't matter because—
Well, I understand that second point, but let me actually a framework question too. Your opponent argues that in our review on both parts of this inquiry is for clear error, and that your burden is heightened, and that the requisite proof has to be, I forget all the adjectives, clear, unequivocal, and decisive. Is it? Am I correct in understanding that for purposes of this case, you don't dispute either of those propositions? So that's our review: is heightened standard of proof and deferential clear error standard with respect to the trial court's conclusions?
That's largely a correct understanding, Your Honor. I don't think we conceded that the objective reasonableness part is reviewed for clear error. We think it is clear error, and thus the court doesn't have to decide that question. But it's certainly true that in Brown and in other cases, this court has said that whether a defendant has an objectively reasonable expectation of privacy is a question of law that this court reviews de novo. In the abandonment context, this court has not explicitly distinguished between the subjective component reviewed for
Well,
clear error.
you say you didn't concede it, but I'm just looking at pages 13 and 14 of your opening brief, where you say, a finding of abandonment is reviewed under a clearly erroneous standard, and then you drop a footnote which says, well, flag issue. Some courts, there's this interesting question floating around out there, but you don't actually make an argument to us that we should do anything different. So I had taken you to have conceded the point. You don't think expressly stating our review is for clear error and in a footnote flagging that other courts have taken different approaches amounts to a concession?
No, I don't think it's a concession, Your Honor. The citation to Spriggs is a quote from that case. And then in the footnote, I note that in Brown, I believe it's Brown, this court reviewed a reasonable, an objectively reasonable expectation of privacy for de novo. We aren't conceding that, for now and forever, that the entire inquiry is for clear error. We don't think it matters here because
Mr. Lenners, a while ago, you repeated two formulations that we have used in our cases: intent to abandon and intent to relinquish an expectation of privacy. Those strike me as very unhelpful formulations, because I doubt that any fleeing suspect has ever thought about abandoning or relinquishing an expectation of privacy. Why aren't we more interested in whether he has voluntarily taken actions which create a situation in which he has no reasonable expectation of privacy?
That formulation certainly makes sense to me, Your Honor. I believe the formulations I recited were direct quotes from this court's decision in Boswell and others. But certainly it makes
But those cases unhelpfully trace back to property law cases, whether something had been stolen or whether it had been abandoned and was free for the taking. And so I'm wondering if we have repeated things unthinkingly without really concentrating on what's crucial for this type of issue.
I agree with that, Your Honor. And I think that's why, courts don't look at subjective intent so closely to try to figure out if the defendant was subjectively giving up a reasonable expectation of privacy. As Your Honor recognized, that seems an unusual thing for someone to do. Rather, they've said that, when a fleeing defendant tosses aside property, he manifestly intends to distance himself from that property so he can escape more easily, or so that it's harder for the government to prove his ownership of it.
I want to circle back around to the discussion of why hot pursuit matters. And let me just ask you a hypothetical. Imagine that in this case, the officer had lost sight of Mr. Kyle before Mr. Kyle got near the fence. And you could see Mr. Kyle kind of looking around, and imagine surveillance footage shows you this from various houses. You could see Mr. Kyle looking around and apparently seeing nobody could see him. And then Mr. Kyle, climbs up over the fence and, puts the bag where it is, climbs back over, and then kind of trots off inferentially, hoping to not be, apprehended by officers who presumably are still in the area looking for him. Do you think that the outcome of this case should be different in those circumstances, or do you think it'd be the same?
No, the outcome's going to be the same, Your Honor, because
sorry for interrupting, because you told me I'll give you a chance to explain, but while you explain, could you also tell me how that case is different in your view from Shreves?
So that case is the same. I mean, that case, the outcome would be the same. It's just like Witten, the 11th Circuit case we cite in our briefs, where the officers lost sight of him. He hid a backpack under a porch, and then when the officers found him, they saw that the backpack was gone. In that case, the defendant knows that he's being chased by the police. He divests himself of possession of an object in an effort to either prevent the police from finding it or in order to make his escape. And so that does not evidence an intent to maintain your privacy in the backpack, your protection of it. The defendant is giving up his ability to protect the backpack.
And it seems to be everything you just said is true in Shreves. So I am still interested in trying to understand why you think the hypothetical I just described should come out differently from Shreves. What are the key differences between that scenario and Shreves that would justify different outcomes?
The key difference in Shreves, and I see that my time is up, and I hope that I am able to reserve some time for rebuttal, but the key difference in Shreves is that it was a car. And as Lefebvre recognized, we all can park cars on the street or in a parking lot of a grocery store or otherwise publicly accessible place without giving up our reasonable expectation of privacy, because this is, as I noted in the reply brief, all that the Fourth Amendment requires is that people take, reasonable precautions to protect their privacy. And parking a car on the street is something that society recognizes as a reasonable measure to protect the privacy of the contents of that.
That may be, but I think you're, no pun intended, a little far afield of what happened in Shreves, because I thought that the car in Shreves was parked on private property to which as far as the case indicated, the defendant had no connection.
I believe it was private property behind a farmer's market. So again, Shreves is a hard case to parse because there's so few facts, but I would describe the parking lot of a giant supermarket as a private property next to a giant supermarket. And just like one doesn't give up one's reasonable expectation of privacy by parking a car on the street, one doesn't give up one's reasonable expectation of privacy in a car parked in a parking lot next to a giant. And so I think
you're right that Shreves is not very detailed. For example, I couldn't tell whether the car was locked or unlocked. I don't know if you could, but it says parked on private land behind a farmer's market. You're saying we should view that as though it was like in a parking lot? Seems a funny way to describe a parking lot.
That's how I understood it to be by identifying it by being close to a farmer's market, that this was a place where people going to the farmer's market parked their car. I didn't understand it to be sort of ditched on some random private property. And I think, and the fact that it's a car, and the fact that there was no active flight from police, I think sufficiently distinguish Shreves from this case. And certainly Shreves gives no indication either when it was decided or subsequently that it intended to adopt a completely different rule than every other jurisdiction with regard to items discarded by defendants who are fleeing from the police. And if Your Honor has no further questions, I would hope to have some rebuttal time.
All right, we'll reserve some time for your rebuttal, Mr. Lenners. We'll hear from Appellee now.
Thank you, Your Honors. Shilpa Satoskar for Appellee Montero Kyle. The government has not shown that the trial court clearly erred here in finding that Mr. Kyle did not abandon his belongings, because the government failed to prove with clear, decisive, and unequivocal evidence that he discarded, threw away, or otherwise relinquished his interest in his belongings so that he could no longer retain a reasonable expectation of privacy in them. And the trial court's finding is amply supported by the record here. And keep in mind, as you know, that this court on review draws all inferences in the light most favorable to sustaining the ruling. And here, the evidence amply supported the judge's finding. The judge noted
Ms. Satoskar, didn't the judge's findings confuse a couple of things? she seemed to be focusing more on property rights and whether there are certain things in that backpack that he would like to retain possession of, as opposed to Fourth Amendment rights.
Your Honor, you're right that she did. One of the factors she looked at was the fact that the backpack contained both contraband and numerous personal important items, such as keys, driver's license, et cetera. But I don't think, first of all, that is something that this court looked at in Shreves as well. I don't think that's a property right analysis. I think it goes to whether the government is trying to argue that the only reason that he had an intent to abandon, because the only reason someone would throw his backpack over that tall fence is to just throw it away, get rid of it once and for all. And I think the point the judge is making and the point the court in Shreves was making is that the fact that there are other items that he would want that are not contraband, that are very important to him, goes to his intent, that he didn't want to just throw it away. And the judge, that was only one of the, excuse me.
I was just going to say, but the Seventh Circuit case, I think Basinski, seems to contradict that and says just because there may have been a desire or intent to reclaim them at a later time doesn't negate the legal determination that it was actually abandoned.
Yeah, well, and that's not the only factor the court was looking at. I mean, it's the court in Smith, which is cited in Boswell, makes clear that the inquiry is whether the person has discarded the item in the open where it's visible and accessible to anyone who's passing by, right? And that's what our court has also looked at as primary factors in Boswell, Biles, and Shreves. And so what the court looked at here was not just the fact that there were personal items there. It also looked at the fact that it relied on the fact that Mr. Kyle carried the contraband and the other items in a closed personal bag where people normally keep their personal effects. He did not, the court says, quote, they were not discarded in a public place. He did not toss them, quote unquote, in the street or alley as he ran, essentially discarding them. So
pick a third of those things. Imagine that this case happened exactly as it did, except when Mr. Kyle tried to get the bag over the fence, it had kind of hit the fence, and instead of going over into the private property, it had fallen back down into the alley. And then, officers covered it from the alley, although obviously Mr. Kyle, let's say in this hypothetical, was trying to get it over and hide it, although it's not very good hiding. The police are right behind you, but they see you do it. But do you think the outcome of that case could be the same as in this case, or do you think that would have to be a dispositive difference?
I think that would be a harder case. I think it would not change the outcome on his intent, because his intent was clearly to hide it behind the fence, and he wasn't successful in carrying out his intent. I think it might be a little bit harder on whether his expectation of privacy was still reasonable, but I don't think it would necessarily come out the other way.
Let me press you on that about his objectively reasonable intent, because the trial judge here didn't really squarely or fully address that issue. If we were to agree with you that there was no clear error, do you agree with Pellin's position here that we'd still have to back to the trial court to do an analysis on whether there was an objectively reasonable expectation of privacy nonetheless?
No, I don't think any remand is necessary here. The government has agreed, as Judge McLeese pointed out earlier, that your review is for clear error on the ultimate finding of abandonment. Now, we agree that the finding of abandonment has two components, a subjective intent component and also a component about whether the person retained a reasonable expectation of privacy. And I think even though the judge may have not used certain magic words, the judge was analyzing both of those prongs when she came to the conclusion that there was no abandonment here, because the part I didn't get to was she talks about factors that go to his intent, that he didn't just discard the item on the ground as he ran. He didn't toss it in the open. It wasn't exposed to view. But instead, she says, he made the effort to throw it over a high fence. Remember, this is a 10-foot fence that you can't see through, you can't see over. And to put it somewhere where it was, quote, not immediately or easily accessible.
That seems a little, it's almost like you play hide and seek with a 3-year-old who thinks that he or she is hiding behind something and isn't. I mean, it wasn't out, it went out of view when it went over the fence, but officers who, at least maybe inferentially, Mr. Kyle knew were right behind him. One officer sees it go over. So if it was an effort to hide it, it was a very poor effort to hide it. It made it harder for the police to get it, certainly in the short run, but I don't know that it was very well designed hiding.
Well, that is true, Your Honor, but that was also true in this court's earlier cases. That was true in Boswell. The police in Boswell, while Boswell may not have known it, they were watching Boswell. They saw him take this covered object down the street. They saw him go into a publicly accessible building, place it in the hallway, and exit the building and go next door. So I don't think that is.
So if you're trying to figure out what Mr. Kyle's reasonable expectations would be of continued privacy in this backpack, it seems to me it's relevant to figure out what a reasonable person would think the police could legally or would naturally do. So assume for a moment that Mr. Kyle knows the police are right behind him. He's got the backpack. He throws it over the fence. They see him throw it. What would he, first of all, what do you think the police lawfully could do? I know you don't think they can treat it as abandoned. I know from your arguments in the trial court, at least, I know you think there's no probable cause for the police to get a warrant and search it. So what do you think the police could lawfully have done relative to that backpack?
Well, I think what they did do, which is apparently just climb on top of a police car and then climb over that fence and go into somebody else's yard, was not something that they could legally do. And I think that, society.
I got that. I'm curious again, if your argument is no, Mr. Kyle would reasonably expect that that's going to remain private. It seems to me that part of that inquiry is, well, no, maybe if the police had lawful options that would have invaded his privacy, then maybe such an expectation would be unreasonable. On the other hand, if the consequence of your argument is that there's no sensible way of treating this property, then that might be a problem for your argument. So I remain interested in your answer to the exact question, which is, what could the police lawfully have done in your view relative to this backpack?
I suppose they could have, well, the government doesn't even claim that they had a reason to either stop Mr. Kyle, or they didn't even have a reasonable suspicion about the backpack. So, I mean, they could have tried to get a warrant to go into that yard and look at that backpack, but I don't think they would have succeeded because they had no valid reason.
Your answer is basically they should have stopped chasing Mr. Kyle. They shouldn't have done that in the first place. I'm not sure that maybe that's right, maybe that's not right. That depends on some issues nobody's really argued about. And in any event, they just needed to leave the backpack sitting there because they couldn't have, they had no basis for probable cause. There's no other exception to the warrant requirement that comes to your mind. So your view is that they had no lawful options other than to just let the backpack sit there and keep thinking about it. They certainly had the option to ask Mr. Kyle more questions. And if he wanted to answer them, then they might have gotten more information. They might, maybe they could find out the court points out that there was no evidence here about whose yard that was. The government was trying to argue that it was a stranger's yard, but they didn't put on any evidence at all about. Well, the court also referred to as a fact that it was the backyard of the stranger.
Where is that? I believe that it was it was a private yard, I believe is what the court said.
Well, the trial court's ruling, at least the written suppression, or maybe it's, I don't know if this is, I'm not sure about the pagination here, but the trial court says, the court notes that while the government argues the defendant threw his backpack into the yard of a stranger, that fact would not have been in the officer's knowledge at the time she was in her backpack.
Right, but the court also goes on to say in the footnote that the defendant's connection or lack thereof to the yard in which she tossed the backpack might have been gleaned if they had investigated further and sought a warrant. I think the court is just saying this.
I thought the court's point there was about timing, and the court, I think everybody concedes incorrectly, was focused on what the officer knew at the time, as opposed to what the actual situation later was to be.
Yeah, I read it. I read the court's comments there as sort of saying that the government is asserting as a matter of fact that this was a stranger's yard, but here's why I don't think that would be relevant, even if true. But in any event, that's not a factor that the court looked at here. And in terms of some of the questions about why his expectation of privacy was still reasonable here. I mean, if we look at this court's cases, such as Biles, what the court looks at to say that the person still has a reasonable expectation of privacy in their property, despite putting it in a location, such as a public place or another person's land in Shreves, a public place in Biles, a public place in Boswell. That doesn't matter because you have to look at what actions the person took to keep their privacy interests. So the court says in Biles, Biles protected his belongings from sight by hiding his counterfeit DVDs in a box underneath his backpack. He hid his ID card in his backpack, even though it was in a public market. He did that so others wouldn't see what was in there. He didn't discard them.
In this case, that seems quite different, at least relative to the property owner. I mean, it's in plain view. As far as you know, he throws it over. He doesn't secrete it, like put it under, hide it under a sandbox cover or something like that in the backyard. As far as we can tell, he tosses it over. So whoever lives there, if you're thinking of Mr. Kyle's as reasonable expectations, I would think he would think, if I can't circle around to get this, if the police arrest me, or if this happens before if what I do startles a homeowner who comes out and looks at it, a homeowner is going to see it, think, I don't know whose this is, open it up and see what's inside and find out that there's contraband, and also whose contraband is. So is all of that thinking relevant to what a reasonable person in Mr. Kyle's could expect about privacy?
Well, all those facts may be true, but they were also true in this court's other cases where there was no abandonment. So in Boswell, when Mr. Boswell left his covered stolen TV in the hallway of a publicly accessible building, anyone who lived in that, it wasn't just one person, it was anybody who could go in that building, just as the police did, and see it in the hallway and lift the blanket up.
Counselor, your answer prompts me to ask, why aren't we focusing on the wrong question here? Why isn't the only thing that really matters is whether under these circumstances your client had a reasonable expectation of privacy in the backpack while it was sitting in the yard into which he had thrown it, what we used to call standing. And why would he have a reasonable expectation of privacy if he's tossed it over the fence and it's in somebody else's yard?
Well, sure, I can answer that. And the reason is that this court has made very clear in Boswell, Biles, and Shreve that you can still retain your reasonable expectation of privacy in your own personal belongings, even if you place them or hide them in a place, in a location in which, in the location itself, you don't have a legitimate expectation of privacy, right? So a public flea market, someone else's land. But what you
I'm talking about these circumstances.
Okay.
He quite visibly tosses it into a yard in which he has no property interest. So it's not hidden in the sense that the officers knew where it went. And we used to care when we focus on search and seizure law as to whether the expectation of privacy was reasonable.
And I think we still do in the abandonment context, but I have a couple of responses. First, the doctrine of abandonment is different in a critical way from standing or other Fourth Amendment doctrines, because it's a doctrine about, in the first instance, everyone agrees that a person has a reasonable expectation of privacy in a certain item, right, or belonging. And the question is, did that person give up their Fourth Amendment rights in that item? And that's why the government has to show it, or the person claiming abandonment has to show it with a heightened standard. And here, we know from this court's case law that you can take certain actions to preserve your reasonable expectation of privacy, even if you put or hide your item in a place where you don't really have privacy interests otherwise. So in Biles, the person protected his items from sight. In Boswell, he did the same thing with the blanket. Here, the court properly relied on the fact that Mr. Boswell heaved his backpack over a 10-foot high fence that
while
see beyond.
while he was fleeing from a police chase, which seems to be a fact, as we queried appellant's counsel about, that is distinguishing, that in Biles, in Boswell, and in Shreves, there was a police chase. That there was no police chase that we have here, where here appellant defendant was fleeing from the police actively and then discards the bag. And we do have other cases that say, even if he intended to go back and get it later, he was secreting it temporarily. That doesn't negate the abandonment finding for Fourth Amendment purposes. How important was the flight or the pursuit here?
Oh, that's a good question. I do want to clear up this issue of flight because the government is relying so heavily on it. Now, we don't think there is anywhere in our court's case law or elsewhere, but particularly our court's case law, that flight is a categorical, there's some sort of, categorical dispositive weight given to flight. There is no bright line rule, as the government keeps claiming, that when someone is fleeing from police and physically relinquishes their belongings, that they have been abandoned. I mean, first of all, in Shreves, the person was fleeing in a getaway car. There was a lookout for the person and their car. So that was a case where the person was fleeing and there was no abandonment. And I want to point out that all the cases in which that the government cites from this court, where the person is fleeing and is found to have abandoned their item while they're fleeing, are all cases where the item is discarded in the open, such as, a gun taken out of a pocket and just thrown onto the street in Smith. In Allison, a gun taken from a waistband and thrown outside. All these cases, and the cases that they cite from other jurisdictions about people who are fleeing and they throw an item over a fence, the majority of those cases are also unconcealed weapons. And those cases, some of those cases are contrary to our case law because they say, okay, the person threw this gun into a location where they had no expectation of privacy in the location itself because it wasn't their land. And we know that that is not the law of this court. And Judge Blackburn-Grigsby, I do want to address your particular question about what this court has said about an intent to go back and retrieve items. I think the way that it's been written about is a little misleading in some of the briefing. If you look at Boswell footnote 10, which is I think what the government keeps citing to say that there is some kind of bright line rule that whenever something is physically relinquished while someone's fleeing, that it's abandoned. First of all, that's a quote from Smith that is talking about how discarding thrown away or discarded in anticipation of police arrest is abandonment. This court found as a matter of fact that Mr. Kyle did not discard or throw away this item. The other thing is that the court goes on to quote Smith, and Smith talks about how where incriminating evidence is discarded in a public area during flight, it doesn't matter if the person intended to come back. So in Smith, the person dropped their gun, I believe, on the sidewalk while fleeing. And then later tried to say, well, it's not abandoned because I was going to come back and get it. That was my plan. And the court says, well, in these circumstances, it doesn't matter that you were going to come back and get it because you've already left it somewhere where literally any person from the moment you dropped it till forever could be walking down the sidewalk and see your gun and take it. So it's kind of irrelevant that you were going to come back and get it. You don't have a reasonable expectation of privacy there. Here, it wasn't the case that no passerby could see Mr. Kyle's belongings. They were behind a 10-foot fence in a yard that was enclosed by this fence. They were in a closed backpack. And
in Spriggs, the object that was abandoned was not visible contraband. It was a container that had contraband inside it. So that's, I'm not saying that's not a relevant point you're making, but it's you would agree it's not dispositive. It's not essential for abandonment that what be abandoned be obviously or apparently contraband rather than in a container. Would you?
Yes, I do agree. I do agree with that. But in Spriggs and other cases like that, the case about the pouch left on the floor of the public restroom, those are cases where the items are in a container, but the container is in open view and is accessible to any passerby. And here we don't have either of those things. We have something that is in a closed container, and the container is not in the open. It's not visible to passersby.
Can I ask you, I mean, if you really want to get very detailed about it, there was a period of time, I'm not sure it's so clear from the video. Assume for a moment there was a period of time where your client has the backpack in his hands, and then he makes some kind of a motion to make it leave his hands. There's a period when it's in plain view, and in fact, it's in view of an officer who sees that happen. And your issue is, like if the officer had been close enough to grab it right then, it would have been in plain view and it wouldn't have been hidden. And then maybe abandoned. I know you haven't conceded that, but you agree it's a harder case. Whereas the key is like where it lands. So it eventually becomes sort of hidden, although very poorly hidden, if you have done that in the view of an officer who's right behind you. Well, why does it matter where it lands? In these circumstances where the officer sees it, discarded, or I don't mean to use the word discarded, it's a debatable term or a vague term, physically separated from the defendant in a public area, and then it lands in a private area and eventually is out of the sight of the officer where the officer happens to be standing at that time. Why does it matter where it lands and where the officer is standing at that moment?
Well, I don't think that we can parse it that thin, like millisecond by millisecond where it was in the arc going from his hand over the fence and into the yard. I think the key facts, which the trial court properly recognized here, were that he intended to hide it. That's why he tossed it over that fence rather than just, dropping it on the ground, leaving it with its broken bottle and continuing to run. And the place where he put it essentially was a place where it was not visible, it was not publicly accessible. And he, just like Biles and Boswell, he took steps to keep it private. And I want to remind you again that remember that in Boswell, the police also saw where Mr. Boswell hid or left that item. So that is not.
Yeah, but the difference, the arguable difference for purposes of what expectations of privacy are reasonable or even actually were held is that it seems in this case, at least arguably, that Mr. Kyle knew that the police saw him doing what he was doing, which is not the case in Boswell. And so if I'm trying to figure out, do I think I'm really keeping this thing private? Again, if, I'm a 3-year-old, I may think I'm private if I'm playing hide and seek and I hide behind something much smaller than me, but I'm really not maintaining any privacy. And there's a little bit of that here where if someone's right behind me and sees me put a thing in a place, I can't, not only have I not hid it very well, but if I know all of that, I can't even reasonably think I did hide it.
Well, I think one goes to intent, and then the other one is whether it's reasonable for you to think that it's still, that you still have an expectation of privacy, right? For example, if I'm running from the police and during the, and I have some kind of contraband, and during the chase, I happen to run by my own car, and I'm a really fast runner. So as I'm running, I quickly, press my key fob, I unlock it, I open the door, I throw my contraband in there, I close the door again, and I lock it, and I keep running. I mean, the officers saw me do that. They know where that contraband is, but have I abandoned it? I don't think any court would say that that was abandoned, even though I was running, because I was attempting to hide it. I wasn't throwing it away. I was obviously intending to keep it safe for myself. And, we know from this court cases.
I would say in that hypothetical, well, I mean, you could infer that I was attempting, the hypothetical person in your hypothetical was intending to hide it, but that wouldn't be my most natural inference, because if the police are right behind, then you would know you're not hiding it. What you might intend to do is prevent the police from getting access to it. And therefore maintain your possession and maintain privacy. But I don't know that that would be really so much a hiding scenario. And again, I'm not sure hiding is the be all or end all of this, because there are scenarios where someone isn't really intending to hide, maybe like yours, where they would still perhaps have a reasonable expectation of privacy. And there are others where someone is trying to hide but wouldn't. So I'm not sure hiding is the end point as opposed to a relevant variable.
Right, and I think that is a broader point that is a correct reading of the cases, that there are no bright line rules here. There is no one factor that is, dispositive. And what this court did was properly look at all the factors and followed this court's case law in Boswell, Biles, Shreves, and found that Mr. Kyle did not abandon his belongings because they were in a closed personal bag. They were not exposed.
So, do you think it would be fair to say that a fair reading of the trial judge's decision here was that she only looked at the subjective factors related to the defendant's subjective intent, and that she didn't look at more broadly at the totality of the circumstances, as you're arguing here, from the perspective of what the officers could reasonably and objectively viewed as the defendant's intent. I get a little confused about how you would frame the test. I hear you saying subjective intent, the totality of the circumstances, defendant's intent to do certain things, but what role do the more objective circumstances from the perspective of the police or any other bystanders play in determining whether there was an intent to abandon the property here?
So I do think that, to answer your first question, that the court was looking primarily at subjective intent, which this court has said is abandonment is primarily about intent. But I think the court was also looking at whether he maintained his reasonable expectation of privacy in his belongings. And we know that she looked at the reasonableness because, she says that rather than, she talks about some facts that in my view, go more to what his subjective intent was, that he, didn't just toss it on the ground in a public place and discard it. He kept his stuff in a personal bag. And then she says he threw it over a high fence. And then she goes on to talk about things that sound more in why his expectation of privacy was still reasonable once his backpack was on the other side of that fence. She says it was over a high fence, it was not immediately or easily accessible. It was not exposed, and it was not in the open. And those are all the same types of factors that this court relied on in Biles, for example, to say that Biles still had a reasonable expectation of privacy in his contraband, because even though it was in a public place, he was hiding it and protecting it from sight. And it's true that anyone who was shopping at that flea market could have gotten interested in what was outside in that stack and just out of curiosity went over and looked. But he still maintained his reasonable expectation of privacy, the court said. And that's exactly what was true here. So the fact, there's no fact that is just categorical. For example, flight, the fact that he was fleeing is not dispositive here because he did not drop his belongings in the open in a way that they could be taken by any passerby. And again, I think the government overlooks how close this case is to Shreves. I mean, Shreves was fleeing in a getaway car. There was a lookout out for him. So I don't think that the government showed by clear, decisive, and unequivocal evidence that Mr. Kyle abandoned his belongings. There was no clear error in the judge's ruling on that. And we would, unless the court has any more questions, we would urge that the court affirm.
All right, thank you, Ms. Sotomayor. Mr. Lerner, we've reserved a couple minutes for your rebuttal.
Thank you, Your Honor. If I might just briefly pick up where defense counsel stopped. If an item is discarded in the open, particularly if it's obviously incriminating, that's abandonment regardless of whether the person is fleeing from the police. A gun dropped on the street, the police may seize under the plain view exception. A backpack left in the middle of the sidewalk with no one around to protect it, it is abandoned, even if it's accidental, as the DC Circuit recognized in most. And so flight is a crucial factor when the defendant knows the police are chasing him and gets rid of something that's in his physical possession. As courts across the country have routinely recognized, that defendant's subjective intent is to give up physical possession and to distance himself from the object he's carrying. As for
if this had been Mr. Kyle's backyard, would you still argue that there was abandonment? Because everything you just said was true, but there'd be an additional fact, which is he might have somewhat different subjective and maybe reasonable expectations about privacy.
That's certainly a more difficult case, Your Honor. There are cases in which courts have found abandonment under analogous circumstances where the defendant tosses the object into his own yard. The California Court of Appeals decision in Young that I cite in the reply brief in the footnote is a case in which the defendant tossed a box into the backyard of an apartment, and he said the backyard was exclusive to his apartment, and the court nevertheless found abandonment. So I don't think.
So, you said it was more difficult. I'm not 100% sure yet. You've told me what you think the answer to that more difficult question is.
So there, I think a court could reasonably find that the defendant evidence of subjective intent to distance himself from the object and therefore to abandon it. I think the reasonable expectation of privacy question is a harder one. And that might be a case in which the government could not appeal the trial court's ruling as clearly erroneous, where the deferential standard of review might come into play. Whereas here, where the defendant has thrown it into either a stranger's yard or certainly a yard that's not his own, this is really an easy case. It's not the government's position that Mr. Kyle was intending to get rid of his backpack once and for all, and the law doesn't require that. As this court made clear in Carlton Smith and in Boswell, the issue is not abandonment in the strict property rights sense. It's rather whether the person voluntarily discarded or otherwise relinquished his interest at the time of the search. And so it's more temporarily limited. The defense keeps saying that the trial court found that Mr. Kyle had an intent to hide his backpack. The trial court never found it. There's no words like hide, secrete, or intent in the trial court's ruling. And to the contrary, as we pointed out in our brief, the trial court below, when faced with that argument, rejected it. The trial court asked defense counsel, if Mr. Kyle is tossing the backpack where the police can see it, how is there an intent to hide or conceal it? And after defense counsel gave his answer, the trial court said that's not a strong argument. This is at pages 139 to 40 of the March 9th transcript. And nowhere in the trial court's subsequent ruling did the words hide appear. I agree with you, Judge McLeese, that it's not dispositive either way, but certainly there's no factual finding that he intended to hide it, which defense counsel repeatedly says. And finally, I would just point out, if this court were to affirm the trial court's ruling here, it would put the police in an impossible situation of having to make these split-second decisions, or when they're chasing someone, whether the place where he tosses his item during flight is sufficiently hidden or sufficiently hard to get to, such that he has, quote unquote, protected its privacy despite abandoning it. And the law doesn't require that. No court has required that. As we point out in our brief, the defense identifies no case from any other jurisdiction finding a lack of abandonment under analogous facts, and that's why the trial court's ruling here was clearly erroneous and should be reversed.
All right. Thank you. We'd like to thank both counsel for your briefs and arguments in this case, and we will take the matter under advisement. And at this time, you're free to leave our virtual court. Thank you. All right. Good morning, and welcome again to the District of Columbia Court of Appeals. This is the second case before us today. Are parties ready to proceed? This is the matter of Ms. Sampay versus American University.
Yes, Your Honor.
Yes, Your Honor.
Okay, counsel for appellant.
Thank you. Jeremy Greenberg for appellant Vanessa Sampay. Reserve 5 minutes for rebuttal, please. May it please the court. This case is about whether the trial court took on the role of the jury by determining that no reasonable fact finder could find that appellant Vanessa Sampay was placed on probation, a performance improvement plan, and ultimately terminated because she engaged in protected activity in violation of the Human Rights Act. The record demonstrates that after Ms. Sampay complained about discriminatorily being verbally assaulted by her supervisor, Hossein Nahidian, that Mr. Nahidian extended Ms. Sampay's probation in violation of American policies. Mr. Nahidian then poisoned Ms. Sampay's performance review in a process that was established from the onset to remove him from the evaluation process. Because Ms. Sampay had voiced concerns about Mr. Nahidian continuing to evaluate her in light of her complaints, appellee rightly set up a process to insulate Ms. Sampay's performance review from Mr. Nahidian's interference and have Ms. Sampay's second level supervisor, Mohammed Mirzabiji, independently evaluate Ms. Sampay's work to determine which, if any, performance issues existed, and to meet Ms. Sampay on a weekly basis. American knew that there was a concern about Mr. Nahidian would not accurately evaluate Ms. Sampay and set up a process to avoid him tainting her evaluation. However, that process was not followed. No weekly PIP meetings occurred with Mr. Mirzabiji to discuss Ms. Sampay's performance under the PIP or help her improve.
Mr. Greenberg, can I interject here briefly to ask you if we are looking at the McDonnell burden shifting test, do you think it's been clearly established that Ms. Sampay met her burden under the first prong of showing a prima facie case of retaliation. In other words, did the trial court concede that? Are we already on to the third prong of whether or not, or are we only focusing on the third prong of whether or not she showed successfully a pretext?
Your Honor,
Reason for the retaliation. Do we get past those first two prongs, and so that we can really only focus here on whether she met her burden of showing a pretext for the retaliation, that any explanation by the university was pretextual? Or do we still have to clear up some of the other prima facie elements of her claim first?
Your Honor, I believe the trial court's decision does rule that she had met those prima facie elements of her case. The trial court goes through the way the trial court structured her opinion was going through each of the various claims that were brought before her at the time.
What did the trial court conclude? Because I'm not sure the record was completely clear on this. What did the trial court conclude was the protected activity that Ms. Sampay had engaged in?
So, Your Honor, the protected activity at issue is that on July 27th, Ms. Sampay engaged in protected activity by first complaining of this verbal assault that happened against her by Mr. Nahidian.
So was it
Sampay then formalized that complaint on February 7th, where she expressly states that she is making a, quote, EEO complaint of discriminatory harassment, and references again the assault that happened the prior week.
So the underlying discrimination was the aggressive contact by Mr. Nahidian in his office on January 27th? Or was it the fact that, because there were some allegations in the complaint about discrimination against her based on her family status. There seemed to be also some allegations or grounds for allegations in the complaint based on her status as a victim of domestic violence, which is protected category under the Human Rights Act, but it's not clear whether that's being appealed here.
Your Honor, the only issue that's being appealed in this case is the retaliation claim. And her complaints are related to that she felt that she was being assaulted by her supervisor in a discriminatory manner because of her absences that she is describing in her complaints that are related to her abilities, including.
Can I ask you legally? I mean, your opponent raises this issue as an alternative ground for affirming the trial court summary judgment motion, that there was a lack of a showing of protected activity. And in making that argument, I understand your opponent to be making the following legal argument as part of their point, which is for your client to make out a triable case of retaliation, one thing that your client would have to do on this piece of it, the protected activity piece of it, would be to show that your client had an objectively reasonable and good faith, so both objectively reasonable, but also good faith belief that the DCHRA was being violated. Do you agree that that's right, that that's the requirement at this stage is not just that your client subjectively and in good faith believed that there was a violation of the DCHRA, but that also that be, if not right, it doesn't have to be right, but at least it would have to be objectively reasonable. Do you think that's a correct statement of the law?
Your Honor, I believe the quotation from Howard University versus Green is a reasonable good faith belief that the practice she opposed was unlawful under the DCHRA, not that it actually violated the act. I'm not sure if the Howard University versus Green case describes that objective.
Well, the word reasonable, I guess, narrowly is thought to, but let me ask you this way, leave aside whatever differences there might be between the word objective and the word reasonable. If you take as a given that your client would have to show that there was a reasonable basis to believe that she was being discriminated in violation of the DCHRA, what is that reasonable basis here? What is, can you explain like what the colorable underlying discrimination claim is? I mean, I know there were substantive discrimination claims, summary judgment was granted and you haven't sought review of them. But if you're explaining, here is the objective, here's the reasonable basis for the EEO complaint on February 7th and the preceding email as a violation of the DCHRA. How would you describe how someone would reasonably think that what Ms. Sampay was alleging violated the DCHRA? How would you explain that?
Well, Your Honor, obviously employees on a day-to-day basis may not know the nuances of the DCHRA. So in terms of what they're complaining about, they only need to voice what to them is an object of a reasonable good faith belief that what's being complained about is unlawful under the statute. So on these facts, Ms. Sampay complains on January 27th, where she describes that she's being verbally assaulted by Mr. Nahidian, that she's came rushing to her from behind his desk, stepped in front of her, was menacing her, shook her hands and fingers at him, and acted as if she was going to hurt her. And then in that January 27th email, she then states how she believes that that's done because she had had these absences that included her having to take time off to deal with counseling sessions with herself and her daughter.
Is the line of thinking assume that there has to be a reasonable belief that the employer was violating the DCHRA? You would say the reasonable belief was my employer is yelling and screaming at me and treating me badly because I was taking absences that I needed to take to deal with family responsibilities. That's the belief. And one issue for us would be, is that a reasonable belief about that something violating the DCHRA?
I think, Your Honor, I think that would be accurate because the DCHRA does expressly include as one of the protected categories family responsibilities. I understand that. I know that the court in some decisions has noted that provision of leave for family responsibilities is not a requirement of the statute, but an employee not being as versed in the case law as the court would not necessarily know that. So all that the employee has to do is complain in good faith that she believes that this conduct is because of these family responsibilities. And then a week later,
I thought earlier you had acquiesced in the idea that it's not just, doesn't suffice that it's a good faith complaint. It has to be reasonable. Reasonable,
yes.
So both of those things have to be true. Is that right?
Yes, Your Honor. And so after she makes that January 27th complaint, she then, in an email, she then formalizes a formal letter saying this is an EEO complaint of discrimination, specifically saying how she believes that she's being subjected to discriminatory harassment, and then references the verbal assault again. And so that's in her written complaint to her formal February 7th complaint to American, which American understood to be a complaint of discrimination and treated it as a complaint of discrimination. And in responding to her complaint, affirmably said, what you've done is protected activity. They write to her in their response to her that while we don't find that there was discrimination, what you've done is protected. Additionally, Your Honor, as I believe noted on page 502 of the joint appendix, Ms. Sampay described in her deposition why she believed in more detail what was happening to her was unlawful in violation of statute. So I believe under these facts, it's clear that Ms. Sampay engaged in protected activity and under the Human Rights Act, either because what she's complaining was in fact unlawful under the Human Rights Act, or I believe she's also established at least that reasonable good faith belief required to engage in protected activity. And
So go ahead.
No, Your Honor.
I was going to say, so if we get to the pretextual prong of the analysis, and the trial court found that the reasons that Ms. Sampay put, well, not found, on summary judgment, the trial court determined the reasons that Ms. Sampay put forward were not sufficient to establish that the university's explanation was mere pretext for retaliation. Why and under what legal framework and standard would we be able to find that that was incorrect?
Your Honor, the standard of review is de novo. So your honors are reviewing the record, reviewing it de novo.
Right, I
And-
understand that part, but in reviewing the record de novo, what would we say? That her assessment of the factual proffers put forward in the complaint was clearly erroneous?
Well, Your Honor,
That we simply disagree and find that those facts did constitute a sufficient basis for the pretext such that the case should go to the jury. I mean, what is it that you'd ask us to be determining in our de novo review?
Your Honor, the thing that we would be asking is that the court review, and because the record shows that a jury in reviewing these facts could disregard American's stated reasons for its decision to extend Ms. Sampay's probation and then ultimately terminate her, was pretext for retaliation. That and that the trial court, in making a contrary finding, overstepped the trial court's role that the jury should have done, and thus the case should be reversed for an ultimate decision by the
So
jury.
it was pretext because, for example, one of the things the university argues is that they were actually trying to help Ms. Sampay, and that's why they extended her probationary period. That's why they put her on a performance improvement plan to help give her more specific goals and targets to meet. Why should that have gone to a jury? That question, I guess, under your argument.
Well, Your Honor, as it first relates to the probation, American has a set procedure that after a certain period of time, probation is automatically ends and the employee goes back to regular status unless the supervisor, by the end of that probation period, fills out paperwork and tells Human Resources that they want to extend the probation. In this case, Ms. Sampay was placed on probation on October 2nd, 2016, and Mr. Nahidian was informed that that probation was going to be through February 7th, 2017. And as of that time, there was no probation extension done. And instead, only after Ms. Sampay formalizes her EEO complaint does that probation then become either extended or placed on new probation overall.
So your argument that was irregular or out of the norm or contrary to the university's standard practice?
Yes, Your Honor, and that's one of the factors that a jury could see in addition to the temporal proximity as evidencing retaliation and pretext. As it relates to the PIP, Your Honor, and I know I have time, but I'd like to address the court's question fully. As it relates to the PIP, knowing that Ms. Sampay had concerns about Mr. Nahidian continuing to evaluate her, knowing that there were these issues about because she made these complaints against him. American laid out at the beginning, okay, Mr. Mizrabishi laid out at the beginning, I'm going to independently evaluate you and I'm going to meet you on a weekly basis to go over your progress on this PIP. And so we can help improve you. That did not happen. Instead, only one PIP meeting occurred. And even then, despite Mr. Nahidian yelling at her during that meeting, because he was also in attendance, Mr. Mizrabishi wrote to Human Resources that Ms. Sampay was improving. Only after that did Mr. Nahidian butt his nose into the process and taint the process and give a contrary evaluation, which, as Mr. Mizrabishi admits, it was Mr. Nahidian, not himself, who ultimately evaluated Ms. Sampay's performance.
Counsel, in my experience, it would be extraordinary to evaluate an employee without consulting at least the first line supervisor, the supervisor who presumptively had the most factual data to contribute. Where in this record is it clear that the university committed to an evaluation that completely took Mr. Nahidian out of the equation, that allowed him no input whatsoever?
Your Honor, on page 530 of the joint appendix, which is the communication of the PIP to Ms. Sampay, it expressly says that, quote, "You have disputed your supervisor's evaluation and raised your own concerns about his evaluation of your work. As a result, I have decided to place you on a performance improvement plan to independently evaluate your work and determine which, if any, performance issues exist." And from that statement, it's clear that the stated intent at the beginning was that Mr. Mitsubishi was to independently evaluate Ms. Sampay's performance. As the record makes clear, that did not happen. Not only under these facts,
but the words you read, which I've read before, do not say exactly what you construe them to mean. It says the performance improvement plan will independently evaluate your performance.
Your Honor, I believe when deposed, and that is also in the record, that Mr. Mitsubishi admitted that the stated purpose at the beginning of the PIP was for him to independently evaluate Ms. Sampay. And he also admits, though, that he then, in his own parlance, delegated that to Mr. Nahidian. And Mr. Nahidian has admitted that he's the one who is ultimately evaluating Ms. Sampay.
Can I ask you a broader question? This is kind of an unusual retaliation case in the sense that most typically, if we're getting a summary judgment retaliation case, there's also being appealed the underlying discrimination claim that is the basis for the alleged basis for the retaliation or cause the retaliation. And that's not the case here. And that, to my mind, makes your client's case harder on pretext in the sense that the trial court, there were a bunch of arguments about this in the trial court. The trial court said, really, there's no triable on some aspects that seem unhelpful to your client about pretext, and that I don't think you to be concretely disputing in this court. So the stated justifications for discharge and for some of the other earlier arguable adverse employment actions where your client was missing work, not giving people without adequate leave, not giving people permission, without giving people adequate advance notice, was performing poorly. And the trial court basically found there's not a triable issue of fact on all that. And also that, they were not treating your client differently from other folks. And you haven't contested any of that. And so it seems uncontested for purposes of this appeal that your client's employer had legitimate basis rooted in your client's poor performance for discharging your client. Am I right? I don't take you to be disputing that, objectively speaking, your client's employer had objectively adequate reasons to discharge your client based on her performance. Am I missing something or part of your brief where you are contesting that, or am I right that is no longer contested, though it was in the trial court?
Your Honor, I believe you are misunderstanding the argument in the briefing. So as relates to Ms. Sampay's performance, I think the record shows that's clearly a disputed material fact. As to
your brief, would I find the argument that says, the employer alleges that my client did X, Y, and Z that led to discharge? That's not true, or at least there's a material dispute of fact about whether my client was performing subpar. I know there is the reference to Mr. The second line supervisor, whose name I'm not going to venture to try to mispronounce, was at one point said a little bit better, but still problems. So I saw that in your brief, but I don't really see an argument that lays out, no, the trial court was wrong when it said no summary judgment, I'm granting summary judgment on the underlying discrimination claim because there are material disputes of fact about whether my client's performance objectively warranted discharge. Where would I find in your brief an argument that there is a dispute of fact about whether your client's performance objectively warranted discharge?
Your Honor, that's on page 24 of appellant's brief, where we discuss how the record demonstrates the material disputes of fact about whether or not Ms. Sampay was meeting or failed to meet her performance standards as described in her in the termination letter. So that's in the brief itself, and those are citations to the record.
So it's that single sentence and then the associated joint appendix sites, but you don't elaborate on what any of the material disputes of fact are. Is that right?
That in the brief, no, that's not laid out in that manner. In those citations are where Ms. Sampay goes through the termination bullet points and when she was deposed, and describes how she disagrees with the assessment that's on there, and that creates the disputed material fact. Additionally,
I thought the structure of this argument also conceded that the employer had objectively reasonable grounds for discharge. In order to get to prong 3, pretext, doesn't the employer have to demonstrate objectively reasonable grounds? And haven't you chosen to contest this on the issue of pretext rather than on the second prong, objectively reasonable grounds?
I apologize, Judge Fisher, if I maybe misunderstood Judge McLeese's question. So American has brought forth what it's presenting to be its legitimate reasons for terminating Ms. Sampay, and as a part of appellant's dispute of that to go to the pretext prong, we have then shown why those reasons are not the real reasons for the termination, in part by disputing the underlying claims of her not performing consistent with the
I had missed that last. You seem to be saying now that you are contesting prongs 2 and 3, and I had not gathered that from your brief.
Well, Your Honor, under the McDonnell-Douglas standard that this court has applied in HRA cases, so Ms. Sampay has brought forth that she's engaged in protected activity, that she was terminated, and there was a causal connection between the two. American has presented supported reasons for terminating her that they're saying is the non-retaliatory reason. And so now Ms. Sampay is, and I believe the record shows sufficient facts that a jury could disbelieve American's stated reasons, and that the real reason for Ms. Sampay's termination was because of her complaints against Mr. Nahidian. So that in addition to disputing.
Usually those arguments play out this way. Yes, the employer had objectively reasonable grounds for discharge, but those were not the true reasons. Their real reasons were discriminatory. But I had not understood you to contest that there were legitimate grounds for discharge.
Appellant is disputing that the reasons given for the discharge are true. So I'm not disputing that what they've purported to be would be objective. I'm disputing that that a jury could find that what American is saying is true and accurate.
Well, were there, is it disputed? I guess what I found confusing, and I'll ask Mr. Remy these questions when he argues, but are you disputing that there weren't unexplained or uncleared or absences and tardinesses on Ms. Sampay's part? As I understand, the crux of the university's concern or allegations about her poor performance relate to absenteeism and tardiness. And so is it your contention that she didn't have an issue with absenteeism or tardiness, or that she did, but that was legitimate because of her domestic violence status as a domestic violence victim, or that she did, but so did other people and she was treated differently than other people? I guess that's where I'm trying to clarify, because I think that goes in part to assessing the pretext part.
Your Honor, as it relates to the specific claims that are in the termination letter, that include a claim that she failed to call in on certain scheduled calls, that is disputed, as what's in the record is regarding the disputed calls was that she attempted to attend, but there was an issue with technology in the bridging conference call. So that is in the record. As it relates to, and there's no other concern about absences that are listed in the termination letter. And so in the focus of demonstrating pretext for the termination, Ms. Sampay then goes, the record shows Ms. Sampay and how she disputes all the remainder facts.
Can I ask you, do you think it is adequate briefing of the question of whether there is a material dispute of fact about whether your client's performance actually objectively warranted discharge was subpar in the way that the employer claimed, to have the sentence on page 24 that refers to some, without describing any material dispute of fact in specific terms, and then has some transfer pages that don't, with no parentheticals about what they're about, and then in the facts portion of the brief, no discussion of any of the facts that would be relevant to whether there really is a material dispute of fact about whether your client's performance was subpar in the ways that were alleged in the trial court, and which the trial court, ended up thinking there were not material disputes of fact, granting summary judgment on those claims as actual discrimination claims. Do you think that's adequate briefing?
Well, Your Honor, as it relates to the trial court's decision, in her ultimate holding, the trial court does not delve into what I believe the record shows are the material disputes of fact as to her actual performance. She focuses on whether or not appellant had demonstrated sufficient evidence of pretext, which I believe appellant has, and as I've gone through in the briefing and during
Are
today's.
you talking about in the summary judgment ruling as it relates to the retaliation claim, or is your point also about the trial court summary judgment ruling as it relates to granting summary judgment with respect to the underlying discrimination claims?
Your Honor, what I'm referring to is where the trial court, which I believe is on pages 20, begins on page 22 of her decision. The trial court does not delve into, because I believe implicitly recognizes the material disputes of fact regarding Ms. Sampay's actual performance. Instead, the trial court focus on, is there in the decision whether or not the plaintiff has provided enough evidence of pretext, which I believe, based on the record, a jury very easily could find the existence of pretext because of those disputes of fact as it relates to her duties, as well as Americans' failure to follow its procedures, that its failure to, from the onset, insulate Mr. Hadian, or setting up or agreeing to insulate Mr. Hadian from this process, and then not abiding by that and having him sort of poison the whole thing and not going with her through the PIP process on the weekly meetings with Mr. Mirzabishi as set up at the beginning.
So, Mr. Greenberg, is the implied part of your argument, or is it explicit or implied or both in your argument, that the performance issues themselves that are being alleged by the university are pretextual and did not arise and were not expressed to Ms. Sampay until she filed, until she reported the incident with Mr. Nahidian in his office in January. And that's because she made that report of what she couched as his abusive, aggressive behavior. It's only after that that issues with her performance are raised and amplified. Is that the crux of what you're saying?
Your Honor, I would recognize that there were previous communications to Ms. Sampay about performance issues, but for, I believe, through most of her employment up through, I believe, 2016 or 2018, she was rated as meets expectations. And then factually, in around the summer of 2016, she gets a new position description. The new position description, I believe there might be some disputes of fact as to what motivated that or what prompted that, but I believe the record is that Ms. Sampay, American, either did not have a position sort of description with her position, or had changed her position over the course of years that they decided to issue her a new position description. So that
was she promoted? Was she promoted? Because that was unclear to me, because it says that she became, yeah, well, let me just leave it like that. Was she promoted, or was it a lateral change in her description, or in other words, she rewarded because her performance was met expectations, or how do we interpret that? Or is that at issue here? It seems to me, doesn't that go to the question of whether there were legitimate performance issues that the university was merely trying to help her correct?
In the summer of 2016, she got a new position description and new title, but it was not related to, it wasn't a demotion, it wasn't a promotion, it was that her existing position description either wasn't no longer meeting what her duties were, or that she needed a new one entirely because they did not have one on file for her. So they issued her this new position description, and as a consequence of that, she then was placed on probation because of just issuing the new position description. And that is what, excuse me, American has asserted, and that is not one of the subjects of the appeal. Ms. Sampay does dispute that, but that is not the subject of this appeal. Instead, it's that then extension of the probation that is one of the items that are the subject of this appeal, that the extension was done in retaliation for her complaint. So absent further questions from the panel, I'll address further questions for the reply.
All right, thank you, Ms. Greenberg. We'll reserve time for your rebuttal. Counsel for appellate.
Sure. Good morning, Your Honors. So
you could just state your name for the record.
I'm sorry, John Remy for appellate. Thanks, Judge.
Thank you.
Just going to this last issue we were talking about, which are the reasons for the termination. It's undisputed. I don't read any dispute of this in the judge's order or in the appeal briefs, that on July 12th, she misses this call. Mr. Greenberg said, well, maybe she had a technological problem. She missed the call. That's undisputed. On July 17th, there are 3 complaints from different divisions across AU to not just Mr. Nahidian and Mr. Merjabeje, but their supervisor, Kamika Sandel, about Ms. Sampay not doing her job. Mr. Merjabeje testifies independently, I thought she deserved to be fired. She's on a PIP, and these 3, you can't dispute these emails that come in, right? Complaining about her. And so then
prior to the February 7th.
I'm sorry, I'm talking about July, and I'm talking about the termination, because with the question, I was just responding to some of the dialogue about, is there a dispute about what led to the termination, about her performance?
Right, and so the actions that you're talking about right now are subsequent to her filing the complaint with HR.
Yes, months afterwards.
Well, but that's my point, I guess, with respect to the retaliation aspect of this, and that I'm trying to clarify. I think so. If we assume for our purposes now that her complaint to Ms. Mirzabagi, Mr. Nahidian's supervisor, about Mr. Nahidian's aggressive actions toward her in January. Mr. Mirzabagi suggested she file a complaint with HR.
Right.
She does that. It doesn't appear to be disputed that Mr. Nahidian is aware that she's filed a complaint against him with HR. And then subsequent to that, we begin to see more aggressive, if you will, documentation of all of these issues that you're citing. And so doesn't that meet her initial burden of establishing what she needs to establish for a retaliation claim? Doesn't mean that it would ultimately prevail with jury, but you have the protected action of filing the complaint. You have the knowledge that the complaint was filed by Mr. Nahidian, and you have the proximity in time between her taking this protected action of filing the complaint and all of these actions toward her documenting now, or more aggressively, arguably, her alleged lack of performance. Isn't that enough initially to take it to, for this matter to go to a jury, as establishing that the heightened scrutiny of her performance under the PIP, which was unusual, and under the extension of the probation, which was not the norm for the university, was mere pretext for for retaliating against her for filing the complaint?
Your
Walk me
Honor,
through.
with all respect, I think each one of those steps is contrary to, you just described as contrary to the record. And each one of them. First of all,
how is the
I can start at the beginning, Judge. I could go through, walk you through
her filing the HR complaint contrary to the record?
Well, first, let's start with the idea that there was no scrutiny for performance before that. What got this whole thing started, Judge, is that she received an expectations memo. First, she received a level 3 written warning in the summer of 2016, right? And then she complained about that, and that got changed to a expectations memo, they called it. She refers to this in the January 27th email, the February 7th complaint, one of those two. It's this expectations memo from 2016. As Mr. Nahidian refers, he told in his communications with her, one of the reasons he was so upset on January 25th, 2017, is he had been counseling her since November to be better about her attendance, to let him know when he couldn't come to work. So this idea that her performance only becomes an issue after she complains is not true. As a matter of fact, the reason she complained, he might have kind of lost his cool, but the reason he complained is because she had an unexcused absence.
Well, I mean, he did lose his cool.
Okay, fine. I'm not challenging that, Judge, right? Okay, he lost his cool, right? But it wasn't like, that's now our third, documented significant performance issue. We've got the expectations memo, we've got counseling from November he refers to about her performance, about her attendance, and then we've got the unexcused absence on January 25th. And so,
well, but how would that negate? How would that negate the fact that his explosiveness and losing his cool in January, and her complaining about that? And his,
well, Your Honor, you had said
for not retaliation, because you could argue that, hey, he feels that he's been trying to help her prior to the January 2017 incident. And then what she does in return for his help is file an HR complaint against him.
Well, Your Honor, that's not even something the plaintiff is arguing. I mean, he wasn't helping her when he started screaming and yelling at her for being late. He was mad at her. He was frustrated with her, right?
Well,
Lost his cool.
because he had, as you said, been trying to counsel her prior to that.
Your Honor, I was responding to your question about, did the scrutiny begin after the complaint? Did the performance concerns begin after the complaint? And the answer to that is no. That had been going on for 9 months or 6 months, at least since the summer. I mean, she says that in her email. She says what she complains about is he doesn't encourage me or provide me any coaching since I got the expectations memo in 2016. That's what she says that's the complaint she's making, right? So number one, this is not something new. In her own words, this is not something new. Number two, the complaint's not protected.
Why?
The reason that we keep that the plaintiff's counsel, appellant's counsel, doubles down on this notion that that on January 25th, she missed work for counseling. He says that in the opening brief and in the reply brief. And it is absolutely false. The subpoena is in the record on page 363. Her testimony, Joint Appendix 335 and 337, admits, I went to court to testify against my daughter. That is, there's nothing about counseling that happens on January 25th. And more importantly,
Counsel, though, that's a little narrow because if you broaden the inquiry to the January 27th email, it refers to more broadly, not just to the incident on the 25th, but earlier, plural absences relating to counseling. So,
right. But Your Honor, that's not what happened on January 25th. Everyone agrees on January 25th, she gets the subpoena on January 3rd, right? January 24th, after business hours, she said, I'm not coming in tomorrow.
On the 25th, my point is, if the issue was her EEO complaint protected, which I thought was where the legal context in which you were addressing this topic.
Judge, I was.
That's the framework for this question. And your point was, I thought, well, the complaint was really only about this, the subpoena issue. And then I thought you were kind of headed down an argument about why that's not protected, why that's not covered by the DCHRA, and that you were losing me at the beginning because it seems to me that her complaint, assuming you can aggregate both the February 7th letter and the January 27th email, her complaint isn't limited to what happened on the 27th or 25th/27th. Her complaint, 25th, her complaint is broader and does refer to counseling. And so if you're going to address legally what is covered by the DCHRA, you may need to address not just subpoenas for domestic violence incidents, but also absences that relate to family member counseling.
Okay, Judge, I will do all that. I will,
where I was headed.
I get it. Now, let me respond to that. First of all, there's never been a claim in this case that a subpoena for a domestic violence absence is the basis for the protected activity.
It's not just the subpoena. It is the whole constellation of the allegation of domestic violence issues within her family that she's experiencing, resulting in the court date, but also ongoing counseling, which is protected, which could be protected under the DC Human Rights Act.
Judge, I understand. The complaint, when we look at the complaint, she is not saying that he is giving me a hard time for prior absences. Those prior absences were never unexcused. There's no allegation that he lost his cool about those or he did anything about those. That's it's not in her complaint. That's nowhere in the record. She is providing context for the traumatic event, right? At the end of that email, where she says the traumatic event, which was the assault, right, that she went to court for. And then she talks about her recent absences, but those absences have nothing to do with January, have nothing to do with her complaint, Judge. There's nothing, she's not saying in there, he's giving me a hard time about those absences.
So I'm looking at the complaint at page 3, which is the Joint Appendix at 8, where there are these allegations about working from home and her daughter was ill and that's why she's working from home. But Mr. Gideon is complaining to her and So I thought the complaint did wrap in some allegations of treatment that of the response by Mr. Nahidian about, her daughter, or I think maybe her other daughter's situation. Am I?
Your Honor, that's not how anybody has, the way we read these last few sentences, which is the only place where this plural absences comes up in this reference to this other issue, right?
Well, I'm at the complaint right now. You're referring, I think, to the January email, but I was just looking at, I was responding to your assertion about the complaint.
So you're looking at when you say complaint, Judge, do you mean the February 7th? I
mean the actual, I thought you meant the complaint, like
no, Judge, I'm sorry. That's the confusion. Okay, I'm talking about the protected activity that happened in the real world, right? At AU in early 2017. That's what I'm referring to. I'm sorry, this is my fault.
No, I can see why we were at
yes, that's exactly the issue, right? But Your Honor, you also made this other point where only on appeal do we get to this issue of the January 27th email being protected activity or being something she was retaliated for, right? That issue, we briefed that. I won't take too much of the court's time.
I think it's a little artificial to parse out the January email from the February HR complaint, because they're all wrapped into her complaining about Mr. Nahidian's treatment of her in his office that day. She goes to Mr. Mirzabaghi to complain about her supervisor and what he did. And then she alleges, and I guess these are two separate questions, her complaint to her supervisor results in an HR complaint. And then she alleges, as I understand it, that the actions against her by her supervisor and then also by Mr. Mirzabaghi accelerate, heighten, intensify, if you will. I guess I'm not sure I understand your argument, which seems to be that even though concerns about her work performance existed prior to her filing her HR complaint, that actions taken after she files her complaint, which are inconsistent with the university's usual practices, couldn't be deemed retaliation. You seem to be saying that just because she had these, I know it was in response to one of the questions I asked you about whether there were prior concerns about her work performance, and you answered that there were. And so, okay, there were. But does that mean that the efforts that the university employed, which appellant contends were irregular based on the university's own policies and practices, to further document or discipline or counsel, whatever you want to call it, her work performance, couldn't be viewed as retaliatory?
Under these facts, the answer is that, John, whether or not there are prior problems, what happened in this case after February 7th could not be viewed as retaliatory based on this record. I mean,
okay,
in the world, is it ever possible?
Why?
Of course, but that's not this case.
Why, in some cases, some of our case law, we have said that where an entity or employer diverges from its usual practices in treating one employee differently, that could be a factor in for a jury to assess that their actions may be protectable and retaliatory.
But Your Honor, a couple of things. Number one, they didn't diverge from their practices. To the extent they did anything like atypical, it was all to help her. Right?
Okay, so they did do things atypically.
Your Honor, I don't know about atypically. Let me give you an example. Typically, when someone has two unexcused absences and within 3 days, which are undisputed, on probation, they're fired. Undisputed. That is an undisputed fact in this case. AU's HR department testified, if you have two unexcused absences and you're on probation, that's it. What happens here? Mr. Nahidian doesn't fire. Instead, they put her on a PIP. And the question about all these process issues, Your Honor, it's not a game.
Well, they extended her probation and put her on a PIP.
Well, I'm talking about the end of March and early April now. I'm just looking at this one piece as an example for you. This issue about the process is not a test of an employer to see if if they've done everything exactly correct in order to be entitled to fire someone. That has nothing to do with the pretext analysis. This court, I explained in the Furline case, right? That when you look at this issue of pretext, you look at the prima facie case, and then what are the employees' reasons attacking the employer's profit reasons? What reasons are false? Is there an argument that she didn't miss work on March 28th or March 30th before the PIP? Is there an argument that these complaints didn't come in? Is it somehow false? None of that. As the judges have pointed out, not even mentioned in the brief, not even referred to in the brief. There's no attacking, zero. The next question in Furline, which the court lays out, is what is the further evidence? Are there comments, right, that show some kind of animus? There's none of that here, zero. And we also have to consider the employer's evidence, which is what I'm referring to here.
Well, one of the
wanted a terminator
in our case law, Mr. Remy, is it's not in and of itself dispositive, but it is a factor for consideration, is whether the employer diverged from their typical practices, treating this employee differently. And I understand the employer's position that any difference in treatment that was atypical was to help her. That's your argument. Their argument.
An argument, Judge. That's a fact. That's a fact.
Well, no, it's your argument, and the appellant's contention is that it didn't help her; it hurt her.
Your Honor, how does not firing her help her? How hurt her? I mean, they had the only. It's not even a process failure. They had Mr. Nahidian. The question about all this, Judge, right? The question about all this is there any evidence of animus? Is there any evidence of retaliation? Why was the decision made? That's the whole point of the case, right? Was it made for retaliatory reasons or made for legitimate reasons? When you have somebody who has the ability under your policy to fire someone where that's typical, and that person doesn't take that opportunity, that must be evidence that he doesn't have the animus to fire her. It can't be, or at best it's neutral. It can't certainly be evidence that he wanted to retaliate against her, even after she complained. So let's talk about the extension of the PIP, the extension of probation. He gets an email on February 23rd that says her probation is ending on March 1st. What are you going to do? Here are your three choices under our policy: extend it, terminate her, or take her off. Well, she has this unexcused absence from 3 weeks before. So what does he do? And the form says, if you're going to extend or terminate, you got to meet with HR. It says that twice, right? So he and Mirzabeji go to HR, and Mirzabeji was the one who told her to complain, right? They go to HR and they extend it because of the unexcused absence. Right?
Now, when you say the unexcused absence, were any of those, what do you mean by unexcused?
It's the January 25th absence, Judge, the one that is unexcused. But Judge, this is another point I was going to make earlier and we kind of skipped over. It's not the reason for the absence. It's not because she was subpoenaed.
That's what I was getting at.
It's not the reasons. It's because he had told her previously.
Were any of these absences when she had previously indicated that she was going to be going to counseling?
No, Judge, it's one absence. It's this. That's what I was trying to explain. It's just this only absence at issue when it comes to this is the January 25th absence. But
you just said a moment ago that she had 2 or 3 excused
absences.
That's
in March. That's after, Judge. That's and there's no counseling. They're just unexcused absences. There's no dispute about that. There's no dispute that those were unexcused, unapproved absences on March 28th and March 31st.
Well, there's two different things. I mean, unapproved could be that she said, "Hey, I need to go to counseling," and Mr. Nahidian said, "No, I'm not gonna excuse you for that." Were there any of those?
Never been challenged, Judge. No, there's nothing in the record about that. They've never been challenged. They're not challenged on appeal. There's nothing on appeal that says those absences shouldn't have been counted against her, or it was by considering them to be.
Well, no, my question's a little slightly different. The employer, of course, doesn't have to excuse every requested absence, for sure. But I'm asking whether any of the absences Ms. Sampay clearly indicated were for counseling related to this family circumstance, which were not excused by Mr. Nahidian.
No, Your Honor. I don't think that's, I don't believe that's true. I have no idea if that's, I know the January 25th one wasn't. That's never been argued about March 28th or March 31st. My understanding is there's unexcused absences from those 2 days, right? There's never been any explanation for why those should be excused or what was happening. She missed work when she didn't get notice, right? And again, even in January,
just focusing on what I take to be kind of an alternative ground for affirmance, that is, there was no protected activity.
yes, that's our argument.
One point your opponent makes, I think, is, I'm paraphrasing here a bit, but if the issue is, did Ms. Sampay have a reasonable belief that she engaged in protected activity because there was a violation of the DCHRA, that the letter that your client sent her about her EEO complaint expressly says it's protected activity and nobody can retaliate. And so one way of looking at that is, if your client said it was reasonable in responding to her, doesn't that tend to support the idea that this was protected activity? She reasonably believed it was protected activity. And what's your response to the significant, if not?
There's no law, Judge, that says the employer's view of it one way or the other. I mean, what if HR had said, we don't think it's protected activity? We wouldn't be arguing that that's relevant, right? It's just not the law. The law is, this is the Vogel case, to constitute protected activity, the complaint must allege an employment practice that is prohibited by the DCHRA. That's that simple. Whatever anyone calls it, what any this is the legal issue. And you're right, Judge, there's got to be an objective belief and a good faith belief that that's true.
Can I ask you if
that doesn't exist?
Let me give you a hypothetical and see if you really stick to your guns on this. So let's say that I'm an employee and my employer in fact discriminates against me in a way that violates the DCHRA. And I write my employer a letter which says, employer, you discriminated against me. And I'm complaining. I'm complaining to you right now. I plan to send a fuller letter, and I plan to let the appropriate authorities know. And you, as my employer, read that and say, "Oh, interesting, you're fired." Well, my letter was totally conclusory. I didn't lay out a violation of the DCHRA. I just alleged one. Are you saying that I have no retaliation claim? Because
that's not the facts of this case.
I'm just asking what your legal.
Okay, my legal conclusion in that case would be that person has alleged a violation of the law, right? And so that is protected. But, John, just to change it a little bit, if they had said, I believe you discriminated against me. I'm a Dallas Cowboy fan, and my manager's a big Redskins fan. And so you violated the DCHRA by doing this. Is that protected activity?
I'm with you 100%. I understand that.
That's this case. That is this case.
No, I'm not quite sure, because if you're focused only on the February 7th letter, it's like my hypothetical, I think. It's just very conclusory. Just says EEO and discriminate. It doesn't really say why. Now, it's different from my hypothetical in a critical way, which is, from your perspective, there isn't an underlying claim or even a good faith belief in an underlying claim, or an objectively reasonable good faith belief in an underlying claim. So it's potentially different in those respects. But I was just responding to your suggestion that the complaint to the employer itself can't be conclusory and has to itself lay out enough so that one can tell what the nature and predicate of the claim is. That seems to me doubtful.
Your Honor, I don't agree with your comment about the February 7th complaint, with all respect. She says in the February 7th complaint, since getting the expectations memo on August 31st, he has increased scrutiny, no coaching or encouragement, and then she's got these reasons, and then it mentions, and I had this verbal assault. You can't divorce these things. This is the verbal assault that she's talking about, which I think everyone agrees. Mr. Greenberg referred to it as discriminatorily verbally assaulted her. There's no such thing there.
So just to be clear,
somebody is not against the law.
If I understand your position, again, which I'm doubtful about, imagine that this exact letter was sent, and then and a complaint was filed, and the complaint alleged that in the verbal assault, the supervisor had used racial epithets and had threatened, and said, "I'm firing you because of your race," and the like. You're saying no retaliation claim, even though there was, and let's say that the claimant ultimately prevails on the theory that that was racial discrimination, and then was fired after the complaint. You'd say the retaliation claim would fail because the verbal assault, the letter described some things and was inadequately specific about the racial or other protected character of the claim. That's if I understand your argument, that's what it is. And if that's your argument, I find that debatable.
No, that's not exactly my argument. My argument, and because I understand, of course, your point there. My argument here is that he yelled at her for not giving notice. She doesn't allege anywhere. It's not the truth. That's just racial epithets. She believes that on the pages in the joint appendix that Mr. Greenberg pointed out in this hearing, I think it's page 506 he mentioned, she says, "I think being yelled at is against the law." That's not against the law. That's not a DCHRA claim. And that's, by the way, and then she says that. She doesn't say, "I believe being yelled at because of my race," or yelling racial epithets is against the law. And that you can't believe that being yelled at is against the law. Say, "I think I'm being yelled at is against the law," and then say it's protected activity, but that's not a reasonable belief. It's no different than the cowboy explanation example.
No, I understand the gist of your point. Mostly what I was trying to get at, I guess, is it seems to me that analyzing whether there was an objective basis for a claim of a violation of the DCHRA runs beyond, okay, the letter was conclusory. I think
that's fair, Judge.
And you got to go
case, that's fair.
into these topics, which you now move to, which is like, what was the underlying basis? I get that, and I understand that your position is this case is like the Dallas Cowboys case, it's just a mistake of law. That's not a reasonable one, right. And not like the hypothetical I was giving. I get all that. I just was somewhat.
That's right. Maybe two things in response about this issue, real quick. Number one, there's no broad ruling here that's going to impact it. We're not saying that a complaint now must say this or that. We're not saying that at all. And the second point is related, which is what's unique about this case is there's no factual dispute about what happened on January 25th. Zero. The subpoena, the late notice, what the yelling was about. This is a little bit of an unusual case. My guess is you get cases where there's a lot of arguing about what happened that led to the complaint, right? And that's certainly my experience with these cases. It's totally agreed upon here. We're taking Ms. Sampay's word for it. That's exactly what happened. It's not against the law. It's not objectively reasonable. It's not, the good faith beliefs are not about what the law covers. They're about whether I was discriminated against based on my race. No, it turns out you weren't, because there's a reason why you were fired. Or whatever, the sexual harassment it wasn't sexual in nature. That's a good faith belief, not the scope of the law, the things that are not covered.
Well, there too, again, I'm not sure I agree or that we have to decide that, but a hypothetical. Imagine that there's a question about how to interpret the DCHRA, and imagine that it's like a recurring question, discrimination law around the country, and some courts have gone some ways and some courts have gone another way. And and my employer treats me in a way that I think is in violation of a reasonable interpretation of the DCHRA, supported by what some courts have said. And I raise a claim to my employer fires me. And for raising that claim, stated reason for firing me. And then I go and I litigate my underlying discrimination claim, and I lose because I lose the legal issue of how to interpret the claim. I'm not sure I do lose my retaliation claim. I'm not sure it really is true that reasonable positions about the law that end up not the scope of the law that end up not prevailing are unprotected from retaliation. That seems quite unclear to me.
Judge, I think two things. Number one, your use of the word reasonable there is exactly the issue. Okay. And number two, I agree with you. We don't need to decide that issue in this case. Like both those things, I'm on board. I didn't mean to suggest that hypothetical. I'm just focusing on these facts, and maybe my language is a little loose in that regard. But it's these facts, right, and this objectiveness. But I just want to just come back to this issue, though, of this pretext argument. Whether it's filling out the form versus going to the HR meeting, this independent notion, which is nowhere, which is a fabrication of this appeal, doesn't otherwise exist. none of these things impact the reason for the termination, right? Mr. Mirzabeji, it's undisputed that he evaluated those complaints and that behavior in July and decided to fire her. There's not a piece of evidence in the record that says Mr. Nahidian said, we need to fire her because of this. And Mr. Mirzabeji said, well, whatever you think. It's the opposite. He says, I independently evaluated that conduct and made that decision. Now, the other point is this. There is no dispute on this appeal that when Mr. Nahidian, this is the point, right? Mr. Mirzabeji never agreed to become her direct supervisor. He agreed to evaluate her performance. Mr. Nahidian was sending, if you look at the emails, right? We gave her this assignment, she did this, she did that, this is what was late, this was on time. There's no debate on this appeal about whether any of those statements were true or not true. There's no claim. There's no claim Mr. Nahidian was sending all this false information and here's the email that's false. It doesn't exist. This idea that independent means Mr. Mirzabeji needed to leave his job and assume Mr. Nahidian's job and become her direct supervisor, as the trial court found, that's not in the PIP. That's nowhere in their policies. Of course he was going to continue to be her supervisor. Mr. Mirzabeji was just going to look at it himself independently. And the best evidence of that, the evidence that proves that's what happened, is that they had a difference of opinion more than a month before she was terminated. I think it's June 14th, Mr. Mirzabeji says, I think she's getting better. Mr. Nahidian says, in my view, there's some improvement, but it's not enough. And then what other evidence do we need that he wasn't delegating it than a disagreement over the quality? And then these other things happen in July. They're the straw that broke the camel's back, or whatever term you want to use, and they lead to the termination. So it's just the pretext. It's just not a game of gotcha, right? It's about what does it reveal about the decision-making process? What's the evidence in that? And there's just nothing here in that regard. So now with the questions, I'm done with my argument.
All right, thank you, Mr. Remy. Mr. Greenberg, we've reserved a few minutes for your rebuttal.
Thank you, Your Honor. First, as it relates to whether or not Ms. Sampay's complaints were protected activity, in the Carter Obi-Uwana case, the court makes clear that an employer's awareness that the employee is engaged in protected activity is an essential part of whether or not the employee meets their prima facie case. And it's clear from the record that American knew that Ms. Sampay was making a complaint, and that complaint was for discrimination, and they recognized it as such and recognized it as protected activity. As it relates to
well, how did they, and I know you tried to address this, so I don't want to rehash your entire argument, but how were their efforts to not fire her when they could have originally fired her, but to spend the time, as they say, to give her more opportunities to redeem herself, if you will? How were those retaliatory actions?
Well, Your Honor, as it relates again to the probation, which under Americans' procedure is that after a certain period of time, an employee is automatically removed from probation and just goes straight on to regular status. In this case, the record shows that her probation was set to expire on February 7th and thus automatically be, and that's on page 189 of the joint appendix, and that as of that date, her probation was not extended. Instead, what American has determined to be the reason for the extension of probation was because of the January 25th absence that she notified the night before. There's no action on that until after she makes her EEO complaint, and no action on that for more than a month when they extend the probation on February 27th. So the fact that if they're saying that they're giving her additional chances because of her absences or performance, they don't take action until more than a month after this issue, her absences brought to their
So you're saying that they missed their window to fire her within the time frame of the original probationary period, if that was their intention, as they seem to suggest.
Your Honor, I think based on those facts, a jury could conclude that the fact that they take no, based on Mr. Remy's representation, that absence could automatically lead to termination for an employee on probation, but they don't take any action until after she makes her EEO complaint. I think a jury could view those facts as showing that the real reason for them extending the probation was because of the complaint itself. And then, Your Honor, I know my time's up, but I also just wanted to bring up one other thing that was brought up by Mr. Remy, was he makes reference to a bunch of complaints that are, I guess, coming at the head in July of 2017. There's no reference to any of that in the termination letter. The termination letter lists, I believe, 11 bullets where they're claiming, I'm sorry, there might be one event in July about a missed call. But there are references to 11 reasons or things that Ms. Sampay supposedly did not meet, which, as the record shows, that she disputes each of those things. And the fact that that American is now saying, we also got these complaints and that justify termination. Well, when an employer changes the reasons for the termination beyond these 11 things that are itemized on this letter, then again, a jury could view that change as supporting that that's not the real reason for the termination, that they are changing their position, and thus the real reason was retaliatory. And I know I'm beyond my time, so unless there's other further questions from the court, I have nothing further except to just state again that this court has repeatedly cautioned trial courts for granting summary judgment in employment discrimination cases because they're inherently dispositive issues of fact regarding an employer's motivations. And as the court said in Blunt, even where it's somewhat thin, an employee's case is somewhat thin, that these facts should ultimately go to a jury. And that in that case, the court noted that while the record in support of pretext was somewhat thin and the employee presented just evidence of her own testimony about her performance and that she disputed the employer's description of the performance, that ultimately that needs to go to a jury. And the court should do the same in this case and remand this back for an ultimate decision for the jury to sort out all these legitimate disputed material facts and determine ultimately the ultimate merits of the case. Thank you.
All right. Thank you. We thank both parties for your briefs and arguments today, and the matter is submitted. And you're free to exit our virtual courtroom at this time. Thank you, counsel.
Thank you.
All right. Good afternoon. Not quite afternoon. Our third and final matter today is Howard University Hospital versus DC Department of Employment Services. Counsel, are you ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
All right. Counsel for petitioner.
Good morning, Your Honor. William Schlatt on behalf of the petitioner in this case. Your Honor, this is an interesting case because it was heard before this court and decided on January 31, 2019, that the matter would be remanded back to the Compensation Review Board in this workers' compensation appeal to review the question of how we interpret a amendment to the DC Workers' Compensation Act. And interestingly, what occurred at the Compensation Review Board level is that there were two opinions issued. The basic issue that was from the 2019 DC Court of Appeals opinion was, is there apportionment under the statute for scheduled loss disability claims? In the opinion that was first issued by the Compensation Review Board en banc, which appears at in the appendix at page 42, on May 21, 2019, the Compensation Review Board reviewed the legislative history and reviewed the statute and determined that, yes, there is apportionment under the Act for scheduled loss disability. And the interesting thing about it is that it was then remanded and then went back up to the CRB, came back down, went back up one more time, and now we're on an appeal from May 21, 2020, in which the same Compensation Review Board en banc again found that there was no apportionment for scheduled loss disability claims. This case really is interpreting the change to section 32-1508, paragraph 6, and a review of why there was concern about this by the DC Court of Appeals in 2019 was that the amendment that was made in 1998 essentially indicated that the requirements of the paragraph would not apply to cases after April 16, 1999. And essentially, the concern, and it's a valid concern, is that the way the Compensation Review Board had been interpreting this provision, you would have to say that the special fund having been eliminated, now all permanent total or permanent partial injuries are subject to the paragraph 6A, which says monetary benefits for permanent total or partial injuries are the responsibility of the employer only up to 104 weeks. When you review this, you see that just doesn't make sense. It wouldn't make sense from the employer's perspective as well as the claimant's perspectives. We do not expect the claimant to have a limitation of 104 weeks simply because they had a prior injury, which is what we're really talking about. The interpretation, and I'm here to convince this court today that the first interpretation that was done on May 2, 2019 is the appropriate interpretation of the Act.
Mr. Slatt, could you, as you're arguing, explain to me why, if your view of the effect of the amendment is accurate, there wasn't a hue and cry from the workers' bar that would have resulted in some legislative history shedding more light on this issue?
Well, Your Honor, I would argue there was a hue and cry, and I've been making this hue and cry for essentially 20 years now. I've raised this issue over and over, and you can see that in fact, the administrative law judge in this case kidded me about it because I've raised it. There is a hue and cry.
Focus, if you will, on the legislative history. We're trying to figure out, among other things, what the council intended to do. And we've searched and searched and searched and don't find any discussion of apportionment or aggravation in the legislative history.
Well, that's I understand that, and that's a problem with this because when you get down to it, either way you interpret it, it's a change from the way it was before. And the legislative history has makes 2 points, and this is pointed out by the Compensation Review Board. There are 2 points of this legislation. And the first point was to try to make DC competitive with Maryland and Virginia for employers. They were concerned because the way in which the DC statute operated, it was not competitive, not as competitive as Maryland and Virginia. And in particular, they were concerned about exactly what we're talking about, scheduled loss disability and how it was being interpreted. The difficulty, and that is where, interpreting this in the sense that that there now is apportionment is consistent with that desire by the DC Council to make sure that it's consistent with what Maryland and Virginia provide. What they did.
But it's also true, I believe, that the council put a 500-week cap on benefits and reduced by, I think, 25% some of the schedule awards. So there was reason to think in those other amendments that they were reducing the cost to employers and thus making DC more competitive, totally apart from apportionment.
I think that's correct. I think that they were the concept was that we were going to put them more in line with what's done in Maryland and Virginia, and that's actually outlined in some of what the CRB said, that they were trying to make it more in line with Maryland and Virginia, which has apportionment for scheduled loss disability.
And so here's a key question then. The CRB states that apportionment is no apportionment. The rule that there is no apportionment, what they call a full responsibility principle, is a time-honored fundamental principle of workers' compensation law that exists independently of statute. I take it you disagree with that, and please explain why.
Your Honor, I do not disagree with that. There is full responsibility. The concept is there's full responsibility when you have a case in which a pre-existing injury has been exacerbated by an injury. There is full responsibility for medical treatment and for total disability benefits in the sense of any time that the claimant is unable to work as a result of this exacerbation of the injury. And in the first opinion, the May 2nd, 2019 CRB decision, they pointed out that is the exacerbation rule. That is the full responsibility rule, is that you are responsible for temporary total and permanent total disability benefits when the claimant cannot work, and you are responsible for the medicals, because you have basically, it's a medical causation issue. The medical causation for this particular injury, that maybe they need additional treatment or surgery, was caused by a exacerbation of a pre-existing condition. That does not hold with scheduled loss disability. And that is not the rule in other jurisdictions with respect to scheduled loss disability. Scheduled loss disability is paid regardless of whether the claimant is losing any time from work. And it is for the injury that was caused by this employment. That's the concept, is that you're going to give a certain percentage disability that's going to pay the claimant. Sometimes it's called the pain and suffering factor. That's sort of not well stated, but it essentially gives the claimant something so that if in the future they can't do another job because their knee is worse, that they're going to get compensated now for the possibility that they might have future loss of wages. By the way, there's no reason why, if they have future loss of wages, they can't come back and ask for temporary total disability. If they are unable to work, or they can show that this injury, the exacerbation of this injury, caused them to be unable to work, then they're entitled to benefits. That's the full responsibility rule. It does not apply to scheduled loss disability. And that's really essentially what the first decision found. They were looking at it in the sense of what is the past, what has been the rule in the past for the District of Columbia before we had created this special fund. And it was that that the full responsibility rule, that you are responsible for temporary total and medicals, but that you're not responsible for anything other than what's medically causally related with respect to the scheduled loss disability.
Help me with standard of review. The CRB en banc changed its mind. Are we obliged to defer to the CRB's decision in this particular subject matter area?
I think that that the standard of review is that you are to look to the agency, the way in which they interpret the statute, in determining that they are the specialists, the experts in this area. And I would argue, Your Honor, that yes, you can look to the CRB because the May 2, 2019 opinion expresses very well the reason.
The CRB has disavowed that. So
I understand
why don't
that.
we have to defer to the latest CRB pronouncement?
I think, though, that you can, when they say defer, the idea is that you look to the agency's interpretation and determine whether that is reasonable. And what I would argue is that the May 2, 2019 opinion from the CRB is a reasonable interpretation of the change in the statute. And that
But the May 21st was an en banc decision that expressly overruled the May 2nd decision. So how can we overlook that? I mean, the May 21st en banc.
You don't have to overlook it because the May 2, 2019 opinion was also en banc. And in fact,
let me ask you the question this way. Let's say we think both of those two en banc decisions are reasonable. Which one do we owe deference to the later? Do we say because they're both reasonable, we'll just decide ourselves? What do we do if we think both of them are reasonable?
I think that you as the court of final jurisdiction have to decide which one you think is reasonable. I think that honestly,
my hypothetical is I think they're both reasonable.
Well, I have some difficulty with that too, because I think they are both reasonable, but I think there are reasons why there is difficulty with the second interpretation, because it tries to do something that the statute doesn't, which is figure out how you're going to account for the fact that a claimant may have already been paid benefits completely paid benefits, and maybe they're entitled to a credit, maybe they're not, but it ignores the specific affirmative statements in the legislative history that their intent was to make it closer to follow what DC and Maryland and Virginia do.
Counsel, you call those specific, but is it right that those statements were made generally about the act and not focused on the particular provision here? Is that true?
They're made generally and about the specific provision because could you tell me where?
Yeah. So could you tell me where in the legislative history, when focused on this provision, the legislative history says we were trying to make this more like Maryland and the like? I mean, the one paragraph I'm aware of that zeroes in on this says something that seems to cut against your view. It says we're getting rid of the second injury fund. So it's describing what's being done narrowly, not saying, oh, by the way, we're repealing apportionment. And then it says, here's the reason why we're doing it. The reason for those funds was they were a way of making sure that employers wouldn't be deterred from hiring workers with pre-existing conditions. But the ADA, the legislature goes on to say, has served that function now, so we don't think that's a problem anymore. Also, the injury fund is an expense to the district. So those are the reasons. The second of those reasons is particularly odd, because if what the council was intending to do was eliminate apportionment altogether, then the explanation here would be, well, we don't have to worry about any concern an employer would have about hiring a worker with a pre-existing condition because we have apportionment now. So, we don't have to worry about the Americans with Disabilities Act or its effects. It's no longer a concern because we're repealing the principle that gave rise to the concern. It doesn't do any of that.
Well, it doesn't, but I would say that the legislative history isn't very specific at all anyway. It's not specific about anything other than indicating, and I think that you're correct that all it really says is we're getting rid of this fund because it's been too much, frankly, the way they phrase it is too much of a hassle for them.
Mr. Schrott, if the legislative history is so unclear, and we, I think, seem to have some agreement that it is, then if we look to the actual legislation, 1993 amendment removed the apportionment language and substituted in 1997 the special fund. Are you suggesting now that maybe I'm not clearly understanding your argument, but why should we now even talking about inserting apportionment or talking about apportioning these damages in any way if that's no longer a part of the statute?
What I'm saying is that 32-15086, paragraph 6A, is what eliminated apportionment, and what the paragraph C says, we're taking this away. We're no longer eliminating apportionment. We're no longer making it so that the employer is responsible for the entire impairment. And I think that the interpretation, the reasonable interpretation that was made in 2019 by the CRB is that means that apportionment is back, because that's the way in which it was before. The law was that.
But how, so it's how is it back? I guess it's not statutory any longer because it was removed. The special fund was supposed to substitute for that, if I'm understanding the interaction between the two. And so it's back in, I mean, was the CRB purporting to interpret the statute or to, as a matter of,
well,
patients say that apportionment is now available again?
Well, the law before the fund is that the aggravation of a pre-existing, as Your Honor said before, was that there is this full responsibility concept within workers' compensation, that you're fully responsible for medical and temporary total disability benefits. But that full responsibility, that running case law on full responsibility also says that you are medically causally related. You are responsible, the employers are responsible for any medically causally related medical treatment, temporary total, permanent total, and scheduled loss disability, but it has to be medically causally related to the new injury. And that's what the full responsibility rule is. And that's why the scheduled loss disability is interesting in that it's sort of a place where you're compensating for and this is what I've been stating for 20 years now, is that what you're compensating the claimant for is what's medically causally related to this injury. So if it's, and in this case is a perfect example.
I'm just not, and it could just be me, but I'm not following what your current position on apportionment is.
My position is in accordance with the 2019 CRB decision, the May 2019 CRB decision, that apportionment applies, and they go to some detail, applies to scheduled loss disability, does not apply to medical.
Even though it's not any longer in the statutory language.
Well, the statutory language eliminated apportionment.
Right, that's my point. So I'm trying to.
And so what, and the 1998 amendment took out the paragraph that eliminated apportionment. So so
you're saying the 1993 amendment that specifically eliminated apportionment was superseded by a later revision of the statute that took out the paragraph that eliminated apportionment, therefore making apportionment there even though it's not there?
Well, it's there. I mean, the issue has always been what is medically causally related to this injury, and that's how apportionment these concepts, these case law concepts.
What was the purpose of the special fund, which seemed to be inserted in the statute after the amendment that eliminated the apportionment?
The purpose of the special fund was made employers, the current employer, responsible for all of the benefits, even regardless of whether or not there was an apportionment. But
but that, I guess that's why I'm asking. It seems like the interaction between the two is that the special fund was put in place when the apportionment rule and language was eliminated as an alternative, different way of assigning, holding accountable the employers.
That's correct. The special fund, the sort of the oddity of the special fund in some ways is that it's actually funded by employers. So, but it's funded by all employers. So there is a idea that the use of the special fund, the concept behind the special fund was that all employers would contribute to a fund that would pay claimants back for pre-existing injuries. Now, as a practical matter, the elimination of this statute does increase the liability to the employer in the sense that now employers, when a claimant is permanently totally disabled or disabled more than 104 weeks, the employer does have to pay, even regardless of what interpretation that I am asserting in this case. The employer still has a higher obligation now with the elimination of this fund. They have an obligation to pay for pre-existing conditions that are exacerbated beyond 104 weeks. That was the limitation before.
Counsel, can we focus on the statutory repeal? And as I understand it, back in the day, prior to 1993, the Workers' Compensation Act specifically endorsed apportionment. It said, this was in what was in 36-3086, says shall be liable only for that part of the disability, yada, yada. That statute was repealed in 1993. Is there any current statute, in your view, that addresses the question of apportionment?
Not specifically apportionment. It doesn't say apportionment anywhere else in the statute. But it does say that, and the case law says that the employer is only responsible for what's medically causally related. And that's—
Is there any case law that takes that language, as you seem to be doing, and says that means that when you get to schedule awards, the employer is responsible only for the part caused by the new injury?
Well, Your Honor, what I would tell you is that the support for that is contained in CRB's decision on May 2, 2019. Now, this is an issue that I've tried to bring to the Court of Appeals for 20 years. It's kind of it's one that doesn't often get to this point. I mean, as a practical matter, this case was originally heard by the administrative agency, was first heard in 2017. So we're now 4 years, more than 4 years later.
Let's focus here. If I'm persuaded to rule in your favor, the best articulation of your argument is found in the 2019 CRB decision?
Yes, and if you read it, I think it does an excellent job of pointing out that by allowing apportionment it's most in line with what the intent of the legislature was, which was to follow what DC and Virginia do in terms of scheduled loss disability, and that appears on page 49 of the appendix.
Let me ask a related but important issue. Do you agree that the question of dollar for dollar credit is not properly before this court? Because in the most recent CRB decision, they declined to address it.
I think it is not before this court in this case. I think you're correct. If I would say that and the reason it's not before the court because it wasn't remanded to determine the dollar for dollar credit, but that dollar for dollar credit has been addressed in a couple of other cases. There's a Catlett case versus Metro that was recently decided by the court that
Counsel, I know we're over time, but I want to make sure it was an aspect of your discussion of full responsibility and also of your argument today and also in your brief that your view about apportionment seems to be zeroed in on scheduled awards. And I took you to concede that like permanent total disability isn't really informed by an apportionment concept. And I'll just make sure I understand that with a hypothetical. Imagine that I'm an employee and I come to my new job and I have already lost the sight in one eye. And then I have a workplace accident that causes me to lose the use of my other eye. I think that under 32-1508 paren 1, that's treated as permanent total disability, the loss of two eyes. But now I lost only one of them for this employer. Is that permanent total disability and you don't apportion, or is that something where you do apportion and it would only be a scheduled award for the loss of one eye? I'm not quite sure I understand what your position is in settings like that.
Your Honor, you would not apportion in that case, and the reason you do not apportion, so long as the claimant can show that he's unable to work as a result of.
Well, there's no such requirement for 1508 paren 1. It's just if you lose both, it's well, I guess in the absence of conclusive proof to the contrary, so the burden would be on the employer. That's just treated as permanent total disability.
Yes, if he comes in, but to be understood, that permanent total disability means that he's not working. If he's working, even though he's blind, he would not be entitled to permanent total disability. But I agree with you that permanent total disability as a concept, because it deals with the wage loss that is medically causal related to the losing the one eye. It just happens that because he had lost the other eye, it's more difficult to find him a job. And therefore,
if I'm an employee and I've already lost like half of the sight in one of my eyes, so my eye is half impaired, and then I suffer an injury so that as a result of my new injury, I have lost complete use of my, the other loss of use might not even be injury. It could be caused by lots of things. And then I come to a new job and I lose half the use of my eye. Your view is that you would apportion if I'm trying to get a scheduled award, and you would view that as only like a 50% partial schedule award. Is that, I just want to make sure I understand what the lines you're drawing. Is that right?
That's exactly correct. Presuming that in that situation, ordinarily, they wouldn't be coming in for a scheduled award unless he was back to work in some capacity. So you come back for a scheduled award when you're back to work. And the reason you're coming back is because it's an award that's made in anticipation of future possible lost wages. So it would be natural that you would, and in accordance with that 2019 opinion from the CRB, that would be apportioned, because we're not talking about. And again, I go back to medical causal relationship, because that's really ultimately what the issue is. When you get treated if he got treated for that for his eye, even though he had lost half use of the eye before, whatever exacerbated it, that treatment is medically causally related to his current injury, and any loss of income from having to be off work as a result of that is medically causally related to the most recent injury. It's just these schedule loss permanency issues that and really that's true in Maryland and Virginia, and I don't know of another jurisdiction that apportions temporary total or permanent total. That's not apportioned because that's not that is a loss that's medically causally related to the current injury, even though there was a pre-existing condition. And I guess I think I've run out of time. So if I have any additional time for rebuttal.
All right. Thank you, Mr. Schlatt. We'll reserve some time for your rebuttal. Counsel for intervener, James Lyle.
Thank you, Your Honor. May it please the Court, I'm absent. I'm on behalf of James Lyle, the intervener in this matter. And in January, Judge McLeese issued a prior decision and gave a mandate to the CRB, which had remand for further consideration of the proper interpretation of paragraph 2E2 and its implications of the apportionment for the act, which is the repeal of the paragraphs that we've been discussing this morning. And the most recent CRB decision, the en banc decision, May 2021, which I think properly should probably be called Lyle 4, because Lyle's 3 is probably the panel decision of January 10th, 2020. But nevertheless, the most recent CRB iteration did a very extensive evaluation and found that the repeal of that portion of the act, what it did was just eliminate the employer's ability to pay less than the full schedule.
Counsel, if I've understood it correctly, the CRB misunderstood Judge McLeese's opinion in the previous Kyle opinion. I'd understood Judge McLeese to say, CRB, you have to decide the effect of this amendment. I now understand the CRB to say, no, we don't, because Judge McLeese already decided that it had repealed all of 15086. Am I right about my reading of the CRB's decision? And if so, is that a problem because the CRB didn't do what we told it to do?
Well, I think the spirit of what the CRB was asked to do was to as the agent that's interpreting the statute for Chevron deference, they were asked to do a deeper dive into the legislative history and intent of the council, other than simply looking at what it called the preamble or the title of the act, and to state their position on whether apportionment exists in the District of Columbia with respect to permanent partial disability in situations where an injured worker has a pre-existing disability and then a subsequent injury. So I think that the CRB did follow the mandate of the Court of Appeals. I don't think it got off course. It ultimately answered the question that everyone in this community needs an answer to. And I wanted to just point to the one question about, there's 2 en banc decisions and which one, if they're both reasonable, which one should the court accept? My position on that is the court should accept the second one, because the CRB in the second one explained the reason why the first one was wrong and why the second one is, CRB was quite specific in terms of why it got together en banc in what is essentially Lyle's 4 and said, we don't believe apportionment exists. We want to make it clear that this is the position of the entire CRB. So the law is clear in the District of Columbia, and the administration of these cases is consistent, clear, and not in chaos, especially given that there is no legislative direction in terms of if apportionment did exist. There's no way to determine the statute how that would all play out.
Could you explain to me why we owe deference to the CRB's most recent decision. Were they applying any particular expertise that they have about workers' compensation law? Or were they engaging in statutory interpretation, legislative action, which is something we can do equally well, or one hopes maybe better?
I think they were acting within their role. I think they are the government agency that is tasked with interpreting this statute. They're intimately familiar with it. And I think the CRB started their analysis there. They looked at the statute and they point out, I believe in the January 10th, 2020 decision and remand order, excuse me, that I'll point this out as well. I think everybody's pointed out, apportionment doesn't exist anywhere in the statute. The words apportionment don't exist anywhere in the statute. They looked at the legislative history. The legislative history doesn't take any mention of apportionment or aggravation principle. One of the judges pointed that out during counselor's argument. And then, they looked a little further at the, what the ultimate purpose behind the special fund and the ADA and how that existed at the time, how the perverse incentive that the Perini case talks about wasn't, the special fund wasn't working to eliminate that perverse incentive. Now we had the ADA and it was costing the district government additional resources to maintain the special fund. So they did an exhaustive review of the legislative history. It sounded like what I heard from, I think you, Judge Fisher, asking Mr. Schlatt was, we searched the legislative history as well, and we can't find anything that pinpoints to the city council indicating that the repeal of the Apportionment Act put apportionment into play in some form or fashion. So I don't think that they're overextending themselves. I think they're just being exhaustive in terms of what they were asked to do, making sure that they did a thorough job, given the gravity of this issue and the impact that it would have on injured workers in the District of Columbia.
Were apportionment and the special fund, I guess, arguably the process for seeking a credit designed to do the same thing? Because there's reference here, I know it may not be directly before us on appeal, but the whole process by which the petitioner could seek a credit if they feel that they're not fully responsible 100% for the injuries in this instance.
The petitioner in this case, or the petitioner in general? I just want to make sure I understand your question.
Yes, in general, but also, I guess my question is, would seeking a credit serve the same purpose that apportionment once served, or could serve if we deem that it's still available? And was the special fund also designed to serve that same purpose, whatever it is, as you would describe it?
Well, I think if a credit was allowed to be sought, it would only create it would carve out a very narrow exception in case where there was an actual credit to seek. In this case, there isn't. There was a prior injury to the same body. Case was settled out of court. The settlement didn't specify a specific amount of permanent impairment, permanent partial disability, or lay out terms of the settlement in which Mr. Lyles was compensated for that particular. So the employer, in this case, couldn't point to the other settlement and say, we get a credit for exactly this spelled out in the settlement. That would be possible. I think it lines up more closely to what I know you questioned my colleague about Catlett, which was when there's the same employer is responsible for a prior award of permanent partial disability, and then that injured worker has a subsequent injury to the same body part, which increases the amount of permanent partial disability on the new claim. That's the Angela Brown case from 2018, the CRB decision, which talked about the credit, which I believe is law. I'm not sure if the court knows what's happened with Catlett since the time that it's been here. I think it's specifically relevant to this case, but the CRB did issue a remand Catlett. It went back to the hearings judge who made a finding that there is no apportionment when there is the same employer. That decision was not appealed on that issue. The appeal had to do with an attorney's fee issue that I believe is making its way back up to the Court of Appeals if it's not there already. So the WMATA in the case gave up the appeal about, or didn't pursue an appeal about whether there was apportionment, same employer. And when the hearing judge said there is no apportionment and followed the CRB's decision in Lyles, the most recent CRB's decision in Lyles, and saying there's no apportionment in the District of Columbia.
Counsel, do you agree with your brother counsel, Mr. Schlatt, that the issue of dollar for dollar credit is no longer before this court?
I do.
So that'll be work for us in the future, right?
It may be if someone wants to bring that mantle up. Yes, Your Honor, it may be.
Do you agree that there is currently no statute that addresses the question of apportionment?
In the District of Columbia?
Correct.
Well, there's no language in the Private Sector Workers' Compensation Act that addresses apportionment. I believe the Public Sector Workers' Compensation Act does contain a provision about apportionment. If you want to apply that to the rationale in this case, it would be if the City Council, who is the legislative body of the District of Columbia, writes the statute, specifically put apportionment into the Public Sector Act, and they did not put apportionment into the Private Sector Act. So, I mean, if I'm answering your question the way I think you want me to, yes, there is a statute in the district that says apportionment, but it's not this statute.
Okay, and I'd be inclined to think it's not deliberate omission, it's just oversight. But assuming there is no statute in the private sector workers' compensation arena that addresses apportionment, is there a default principle about apportionment that governs in the absence of statute?
I think that's what you and Mr. Schlatt were referring to as the full responsibility rule, also called the aggravation rule. Essentially that, if an employee aggravates a pre-existing injury, the employer is liable for the injured worker for the entire resulting disability. And I heard Mr. Schlatt argue that he's actually in favor of the aggravation rule or the full responsibility rule. And I also heard him argue that that's 32-1508 paragraph 6A was repealed, and the repeal of that particular paragraph it potentially brings apportionment back. That paragraph is the aggravation rule, right? That is the aggravation rule codified in the statute. What Larson's tells us is that the aggravation rule is not dependent on, it's a fundamental concept of workers' comp that is not dependent on statutory creation to have its existence. It's just a fundamental principle of workers' comp. So if you think about the statutory construction of the repeal of that provision, what the repeal of that provision is paragraphs, is eliminating the special fund, which we have probably the clearest picture of legislative history about why the special fund was put into place, because it was an incentive at the time to have employers hire and retain employees with prior disabilities. And then why it was repealed, because the ADA came about and that incentive wasn't being fostered any longer, and it was having a cost to the district government. I think
just as a follow up on Judge Fisher's question, it seemed as though your opponent might be arguing something along the following lines. And if so, I'm interested in your response either way, which was you may be right as far as you go that there is a default principle of full responsibility, but that default principle runs only as to medical expenses and various other components of the statute. But he seemed to suggest that actually, with respect to scheduled awards, the default principle is the opposite. And I'm wondering whether in Larson or elsewhere that you've seen, you think that the default principle might be limited to certain types of workers' compensation disability benefits, or whether you view it as a default principle that applies across the board.
I view it as a default principle that applies across the board. I mean, if every other concept in workers comp, if it applies to every other concept in workers' compensation, medical treatment, temporary total disability, permanent and total disability benefits, even temporary partial disability benefits where the person has a partial wage loss and they're working in some capacity and earning less money with restrictions based upon the subsequent injury. No apportionment applies to any of those scenarios. So why would permanent partial disability schedule member apply any different? And the longstanding tradition in the District of Columbia, the humanitarian purpose of the act has never been to take away from the injured worker. It's always been to try to give the injured worker the full benefit of the rights and benefits associated under the act. It's never been, the policy's never been to take it away. Even when there was apportionment prior to 1993, I think what they were using at that time was some version of the Longshoremen's Act or some interpretation or some reiteration of it, but there was still some special fund relief that was available. And then after the 1993 amendments, apportionment was eliminated and the special fund was put into play because of the perverse incentive that was talked about in the Perini case. And then we have the ADA and there's further evaluation of whether we need this special fund or not. And there's an economic consideration that the government did, but at no point did they ever say, let's change the system completely, take away from the injured worker and give the employer or reduce the liability of the employer. In no way did they ever attempt to reduce the liability of the employer other than what is essentially a byproduct of the special fund, which wasn't put into place to benefit the employer. It was put into place to give the employers in the district an incentive to hire individuals with prior disabilities.
Let's go back to Larson for a minute. As you say, he says that there is a default principle of full responsibility. He then cites a bunch of cases, jurisdiction by jurisdiction, and when it comes to the District of Columbia, he cites Safeway Stores, which relies upon 15806, which has now been repealed. So I'm wondering what the default principle is in the District of Columbia.
Well, like I said earlier, Your Honor, I think if 15806A is the aggravation principle. It's a codified version of the aggravation principle. I think what the CRB was saying, and I tend to agree with this, is that provision being repealed, the only effect that provisions being appealed has is that it eliminates the special fund. The concept of the aggravation rule exists, and it exists in case law. And it's been almost 23 years since the amendment went into effect. There's been 23 years worth of cases, except for a little window in 2019 when there might have been apportionment for a couple of months following what was essentially Lyles 2, where the rule of law in the District of Columbia is that there's no apportionment.
If you're right about what the legislature intended, one might have thought they would have left most of subsection A intact, but have repealed the portions that relate to the special fund.
Perhaps, but I think we all can acknowledge that we have what we have in terms of the legislative history, and anything other than that, we're doing our best.
All right. Anything further, Mr. Capson?
No, Your Honor, I appreciate your. Thank you for speaking with you.
All right, thank you. Mr. Schlatt, did you want to take a few minutes for your rebuttal argument?
Just very briefly, Judge Fisher was talking about the standard for review and the issue that comes up with respect to which one you have to consider. And I think under the standard for review that there is that the reason why you defer to the Compensation Review Board is for their expertise with respect to workers' compensation, and not for their expertise in terms of interpretation of a statute. So I think this is more for the DC Court of Appeals interpretation of a statute. And I wanted to specifically point out one of the issues, the problems that I have with what's being called Lyles 3, which is the May 2020 decision. And that is that it states on page 10 in the second paragraph that the previous en banc decision did not give appropriate weight to the fact that none of the documents for the council, when it considered the 98 amendments, stated that the amendment's purpose was to provide for apportionment. And none stated that the amendment was to reduce the amount of monetary benefits payable to the injured worker by a new employer. The problem with that statement and the problem with their use of that weight is that, in fact, the new statute requires the new employer to pay a lot more. This isn't, when I say the apportionment comes back in, but what's being not stated is that what the obligations that the special fund used to pay, which is over 104 weeks, and medical benefits, well, over 104 weeks as it was in 1998, is significantly more for the new employer. The new employer, because they pay temporary total and permanent total disability benefits, which there was a mention of the 500-week limitation. 500 weeks does not apply to permanent total. This change in the statute significantly increases the exposure for the employer for temporary total and permanent total disability.
I think I agree with your reading as related to the new employer. Isn't it, in fact, decreasing the amount received by the worker by putting a 500-week cap on it?
Well, Your Honor, it does. By experience, it mildly decreases it. But if you think about it, if someone is out of work for 500 weeks, and by the way, there's a provision to extend it another 606 to another 167 weeks. So the limitation is really 667 weeks. But if you think about that, that's 10 years of benefits. Now, in experience, 10 years of benefits is going to be someone who's permanently, totally disabled. So it falls outside that provision. So in essence,
the practical effect is small.
The practical effect of that limitation is small. But the practical effect of making the employer responsible for anything over 104 weeks is very large. Now, they were assessed under the special fund rules, and I understand the elimination of it because it was complex, and it required a lot of additional work from the District of Columbia. But if you read this provision, the portion that I'm looking to is really, this is the issue that this court has. How do you interpret the statute based upon what's been stated? Yes, it doesn't say anything about apportionment in the legislative history, but it also doesn't state that there is a significant increase in liability of the new employer because they have to pay everything over 104 weeks. So I think that and in fact, what I'm arguing for, as a practical matter, the change in the statute significantly increased the liability for employers. So this small apportionment issue for what is essentially, and I emphasize the issue of medical causal relationship, because that's what ultimately we're talking about. What is causally related to this injury, this new injury? If the claimant's out of work because he's temporarily totally disabled because of a new injury, the new employer is responsible because that injury caused him to be out of work. If he becomes permanently totally disabled, that new injury caused him to go out of work. But when you get to the scheduled loss disability, medically causally related is only that condition. And the doctors, and we have this AMA guide, the AMA guide has been included to show percentages. And in the AMA guide, they have provisions in there about how to determine what's pre-existing and what's current and what's the new injury. And all these that is, and I would emphasize that the legislature indicated that they wanted to put themselves in line with DC, with Virginia and Maryland, which both provide apportionment only with scheduled loss. So, Your Honors, I think that we're in an interesting position in this case in which we have two CRB decisions which examine and come with the exact opposite conclusions. I do think that the 2019 opinion, the May 2019 opinion, is more in line with what was intended by the legislature and intended by, when you read the statute, that is what that provision of the law ends up allowing for apportionment. Thank you.
All right, thank you. We appreciate both counsel and your briefs and arguments today.
Thank you, Your Honor.
This court is now adjourned.